May I, Lordship?
Yes.
Lordship, I would like to mention item number 17, Lordship. Lordship, may please to allow to withdraw, Lordships. This is transfer posting method, Lordship.
You want to withdraw it?
Yes, Lordship.
Mr. Your good name?
G. Bam, Lordship.
Learned counsel for the petitioner submits that he has the instruction to withdraw this petition. Paid is accordingly allowed. This WPC number so and so so and so. That's disposed of on withdrawal. One IA is there.
IA is, Lordship, is caveat and interim. My interim is vacated, Lordships. So there is no any interim order in favor of me, Lordships. Transfer
So
posting
that
order.
IA has to be closed.
Yes, Lordship, everything may be closed, Lordship.
IA. Right. Yes.
Lordship, one more, Lordship. List for tomorrow, Lordship. One tender matter, Lordship, for withdrawal, Lordship. Tomorrow, Lordship. Much obliged, Lordship.
May I please say, Your Lordship, I beg to mention item number 5, Your Lordship, on
Yes.
behalf of Mr. I. Ram, additional senior government advocate. He is having some personal difficulty, Your Lordship. He has instructed me to take adjournment of this matter and fix it after winter break, Your Lordship.
When?
After winter break.
After break.
Yes, yes.
Your good name, please.
P. Sangeeta,
So learned counsel appearing on behalf of Mr.
I. Ram.
Learned counsel for the petitioner. Let's raise the matter after winter break.
Obliged.
Yes.
Obliged.
My acknowledgement.
Yes.
This contempt petition is, my lord, in pursuant to the order passed by this honorable court in WPC number 2 or 627, 2023. My lord, may kindly come to the page number 15. Is the, my lord, operating portion of the order passed by this honorable court, where
Page number.
1515. Wherein the court has directed to dispose of the representation within the 2 months, whereas it's almost 12 months, but contempt order has not taken up the matter. So, my lord, para 15, my lord, got it? Page 15. One five.
Yes, got it.
Considering the petitioner by file, this petition has only sought for the direction to respondent authority to dispose of the representation dated 15/11/2023. This court deemed it fit appropriate to dispose of the writ petition without entering into the merit. Accordingly, the writ petition is disposed of with a simple direction to the respondent authority to consider and dispose of the representation dated 15/11/2023 within the 2 months from the date of the receipt of this copy of this order. So accordingly, my lord, I have placed this copy of this order before the contempt on 27 December 2023. But till today, this has not been attended, my lord. Therefore, my lord, this is clear contempt, clear card of the contempt.
Have you served notice upon the respondent?
My lord.
Anybody representing the respondent?
No,
The contempt?
no, my lord, since this is the matter is come for the first time, my lord, let the notice be issued, my lord.
Heard Mr. C. Modi, learned counsel for the petitioner. This petition under section 12 of the Contempt of Court Act 1971, read with article 215 of the Constitution of India and rule of contempt of court, Guwahati High Court rules 1977 is preferred by the petitioner, Sri Karsing Bara, for non-compliance of the order of this court dated 22/12/2023 in WPC number 627 of 2023. Peruse the petition under documents placed on record and also peruse the order dated 22/12/2023. Let notice be issued to the contempt returnable in for which step be taken by registered post with AD and also by usual process within a week from today. List the matter after for its.
Obliged.
May I please, madam?
Yeah.
I'm here for a limited prayer for disposal of the representation matter. Madam, petitioner is by qualification is a dental surgeon, madam. Has come across a madam advertisement dated 30/10/2024 for walk-in interview for contractual appointment of dental surgeon, madam. Lordship will find the advertisement at page 22, madam.
Yes.
22, my lord.
Mm.
It's a advertisement, my lord. Applications, first paragraph, my lord. Applications are invited for walk-in interview from the bona fide candidates of the Arunachal Pradesh Scheduled Tribe, my lord, for filling up of one post of dental surgeon under National Oral Health Program purely on contractual basis under the NHM. The detailed requirements are as follows, my lord. And accordingly, my lord, I also, my lord, submitted my application, lordship will find at page 24, my lord, having all the requisite requirements, my lord.
Mm.
My application, lordship, is at page 24, my lord. Submitted my application with all the required testimonials, my lord. Thereafter, my lord, the deputy commissioner is the chairman of the appointing, he is the appointing authority, my lord. My lord, accordingly, a list of the my lord, candidates were published, lordship will find at page 38, my lord. These are the list of my lord candidates, my lord, with roll numbers, my lord.
Mm.
Only 12 persons were called for, my lord, selected for, my lord, walking interview, my lord.
Mm.
My lord, total, my lord, 12 persons, candidates, my lord.
Mm.
And the date of interview is in bold letter, my lord, fixed on 18/11/2024, my lord.
Mm.
And I find, my lord, my name is not, my lord, appeared in this list, my lord.
Mm.
So I made a complaint before the deputy commissioner, the chairman, my lord. Accordingly, my lord, a revised list was published, my lord. Lordship will kindly see page 39, my lord.
Mm.
On the same date, my lord,
Mm.
14/11/2024. And my name was also shown in the list at serial number 13.
Mm.
Dr. Nick Payo, my lord.
Mm.
And in the bold letter, my lord, date of interview was refixed on 18 November 2024, my lord.
Mm.
On the said date, my lord, by the, my lord, DMO, respondent number 3 and 4, superintendent of medical, my lord, literally, my lord, pushed away me, my lord. I was not allowed to participate in the interview process, my lord. My lord, thereafter, on the same date, my lord, result was published, my lord, at page 42, my lord. And on the same date also, before the publication of result, on the same date, my lord, I have submitted representation also at page 40, my lord.
Mm.
Type copy is, my lord, page 41, my lord.
Mm.
On the same date, 18 November 2024, madam. May I read my application, madam? To the Deputy Commissioner, madam. Sir, with heavy heart, I have to inform you that I, Dr. Nick Payo, has not been allowed to appear the walk-in interview on 18/11/2024 by medical superintendent and DMO, even after my name, Dr. Nick Payo, and roll number such and such being published by such and such published on 14/11/2024. I request your good office to cancel and reconduct the said interview as I am bona fide candidate with all necessary documents required. Otherwise, I will have to, my lord, may skip this matter. Thereafter, my lord, on the same date, a result notification was also published, my lord. Page 42, my lord.
Mm.
Selecting on the same day, 18/11/2024, selecting one respondent number 4 for the said post, my lord. My limited prayer is that, my lord, is violates my Article 1416, my lord, purely, my lord. I was not allowed to participate in the selection process. So, my lord, I have already filed a representation, my lord, for consideration of my case, my lord, to appear before the, my lord, committee selection board, my lord. I pray that, my lord, let my lord, representation be considered by the deputy commissioner, who is the chairman, my lord, till the consideration of the, my lord, the representation, let the result be, my lord, subject to outcome of the disposal of the representation, my lord. At least I have a right to, my lord, appear in the selection process, my lord. Let the,
Anybody for respondent?
Lordship, I'm for respondent number two, Lordship.
Yes.
Considerations of revision, I have no objection on that, Lordship.
So why he was not allowed to participate in the?
Lordship, that part, Lordship, I have to take instruction if that is to be obtained.
Can you obtain instruction? We will take it up at 2 o'clock.
Today,
Because
if tomorrow, Lordship,
tomorrow.
or another my lord may dispose of the representation, my lord. Saying that, my lord, this,
Why you have not been allowed to participate?
they are saying that, my lord, I am from another district, my lord. So it is only for the domicile of the, my lord, Changlang district, they said, my lord. But, my lord, advertisement clearly says, my lord, applications are invited from, my lord, the scheduled Arunachal Pradesh, scheduled tribes, my lord.
Then
Both the, my lord, DMO and the, my lord, the superintendent of medical has restricted me for in the appearance of the interview, my lord, in the appearance of the interview, my lord. I have especially made an environment, my lord.
no, since there is a prayer for staying the publishing of the result. No, what was your interim prayer?
My prayer is that, my lord, let the deputy commissioner dispose of my representation, my lord, whatever in the manner, my lord, until the disposal of the representation, the result notification shall be subject to outcome of the disposal of the
No,
report.
they have already published the result.
Yes, my lord. So, my lord, my lord, that's why my lord may interfere by saying that, my lord, till the disposal is, my lord, disposal, my lord, of the representation. Or result, my lord may not say the result, my lord. The appointment of the private respondent shall be outcome of the disposal of the representation.
Now, let us do one thing. Mr. Tapping will obtain the instruction by tomorrow morning.
My
So we'll take it up.
my.
Heard Mr. R. Soikia, learned counsel for the petitioner, and also heard Mr. Tapping, learned senior government advocate for the respondent number two. Then
1, 3, and 4.
1, 3, and 4. List the matter tomorrow so as to enable Mr. Tapping to obtain necessary instruction by tomorrow. Let's just list the matter tomorrow morning.
Okay.
Item number 3. May it please your lordship. My lord, I am appearing virtual mode, my lord.
Yes.
My lord, my grievance is very limited, my lord, here. My land has been surveyed, my lord. But in the draft list, my name did not figure, my lord. Therefore, I have filed my representation.
Why your land was surveyed?
My lord, this is for the purpose of acquisition for construction of the frontier highway, my lord. The portion is Kharsang, Miao, Vijayanagar stretch, my lord. So my land is situated in Vijayanagar circle under Hazulu village, my lord. So all other landowners, most of the landowners, the lands were surveyed, and the name has come in the draft list, my lord. And the survey passes through my land, my lord, my agricultural land. Yet my name was not did not appear in the list. So I have filed a representation to the deputy commissioner. Deputy commissioner has disposed of my representation, my objection, my lord, by the impugned order dated 24th July 2024, my lord. That is
At page number?
49, my lord, page number 49.
Yes.
Page number 50, the relevant portion will be page number 50, para number 10, my lord. May I read, my lord, para number 10?
Yes.
Para number 7 or 9 onwards, I'll just come back. Whereas Shri Liakhu Yobin appeared in person during the hearing conducted on 09/07/2024 in respect of his claims and objections. Number 10, Shri Liakhu Yobin, white letter number dated 08/7/2024, submitted his claims and objections on 9/7 during the hearing. The point of contentions were that not to disburse the land compensation amount located at the banks of Wanalu River of Hazulu village as marked in the map attached, as he is the sole owner of the aforesaid land and has been in his possession since past 31 years. That this land and name has not been listed in the survey report. Similarly, other landowners of their lands lying in between his land, that is serial number 113 of Popita Yobin, not been listed. Peruse the claims and objections letter of the person concerned. Point number 1. With respect to point number 1, not to disturb the land, disburse the land compensation amount located at the banks of Wanalo River of Hazulu village as marked in the map attached, he is the sole owner of the aforesaid land and has not been in his possession and has been in his possession since past 31 years. The applicant needs to point out who are the ones enlisted as claimant/owner of the land as claimed by him. Proper SL numbers and changes need to be mentioned in his claim as given in a draft list so as to ascertain the identify other enlisted claimants. However, such has not been done in the case and therefore not admissible. Point number 2, with respect to point number 2, that his land and name has not been enlisted in the survey report. Similarly, other landowners and the lands lying in between his land and serial number 113 not been enlisted. There is no person by the name of Popita Yobin at serial number 113, and that as per the report of ESC Vijayanagar White letter number so and so 17th May 2024 enclosed, intimations were already given to landowners along the proposed frontier highway to remain present during survey assessment exercise. Therefore, the point of contention is not admissible. In the instant, so my lord, these are the two grounds. First of all, he says that I need to mention a proper chainage and I need to mention the proper the identity of the land, my lord. May I just take a moment to submit, my lord? When the landowners were not aware when was the survey being conducted or when the survey is going to be conducted, my lord, these are all villagers, my lord. They will be almost all the time in the jungle doing cardamom gardening or in the jungle cutting firewoods, my lord. They would not know, my lord. So he missed the bus. He missed the bus when they came to survey. But later on, he came to know that his land has been surveyed, my lord. This is what we are asking. Give us an opportunity, kindly direct for resurvey, my lord, so that at least since that is not a disputed fact that the land, the proposed highway is not going through my land, my lord. It is not a case. But the way the deputy commissioner has disposed of by applying one of the judgment that he has referred later on, seems as though that I am not interested to give my land for compensation. He is saying that the public interest will always it will be always bigger than the private interest. That's not my case, my lord. I am only saying that you take the land, but at least let my name be there. Let a compensation, whatever in accordance with law that I'm supposed to receive, give it to me. Take the land for the public interest, for the interest of the nation. That is all I was saying, my lord. But this impugned judgment has disposed of by otherwise saying something else, my lord, as though that I am not interested to give my land or I am not interested to part my land, my lord. That is not the case, my lord. Therefore, my humble submissions, my lord, would be, my lord, for direction to the deputy commissioner to fix a date, let the ESC resurvey, let I be there, let other landowners be there, my lord, so that there may not be a multiple litigations later on, my lord. That is all, my lord, I have to pray, my lord.
Yes, for the respondents, anybody?
My lord, in fact, if the petitioner is agreed, my lord, under section 64 of the right to fair compensation act, he has an alternate remedy to approach the authority, my lord. Authority designated under section 50. After the collector, if my lord kindly see section 64 of the right to fair compensation.
Yes.
Any person interested who has not accepted the award may, by written application to the collector, require that the matter be referred to the collector for determination of the authority, as the case may be, whether his objection be be to the measurement of the land, the amount of the compensation, the person to whom it is payable, the rights of rehabilitation so and so, or the apportionment of the compensation amongst persons interested, provided that the collector shall within a period of 30 days from the date of receipt of application make a reference to the appropriate authority. Provide further, my lord. There is the authority, there is an appropriate authority which is defined, my lord, as per section 50, my lord. My lord, the definition of the authority. There is authority definition section 3F, my lord.
Yes,
Authority means the land acquisition and rehabilitation and settlement authority established under section 51. And section 51, under section 51, the authority has to be appointed, my lord. And qualification is under section 53 of the. It should, the district judge Section 53 says qualification for appointment as presiding officer. A person shall not be qualified for appointment as presiding officer of an authority unless he is or has been a district judge. B, he is qualified legal practitioner for not less than 7 years. My lord, I believe this under section 51 already the authority has been appointed, my lord. The district judges have been given designated as the authority. So this whether the writ will be maintainable when there is a dispute, whether his land is been taken or not, that is for the authority to be to decide, madam. He will have to establish that his land also is being acquired. And even section 76, my lord, when there is a dispute with regard to apportionment. When the amount of compensation has been settled, if any dispute arises as to the apportionment of the same or any part thereof, or as to the persons to whom the same or any part thereof is payable, the collector may refer such disputes to the authority. I don't. Therefore, whether his land is actually being acquired, his land holds within the acquired portion, my lord. That has to be determined, my lord. Already survey has been done. Maybe his land does not fall under the acquired portion, my lord.
can
So-
you obtain instruction?
Yes, my lord. Because may I very quickly revert to my friend's submissions, my lord. Section 64 will not will not come the way of my writ petition. Why? Because, my lord, I am not challenging the measurement of the land. I am not challenging the amount of compensation. Neither I'm challenging who is entitled to be paid, my lord. Nothing as such I'm not challenging, my lord. If that be the case, my application could have been referred to the authority under section 64 by the deputy commissioner himself by exercising. So therefore, today he cannot take two views, my lord. When my application was pending before him, and he has disposed of with this application. Therefore, my lord, yes, my lord, the notice instruction
My
should
lord, in that event, if he says that section 64 will not be applicable, notice maybe you will file our affidavit, my lord.
my lord.
Whether his
Okay.
land, yes, that
That notice good then.
Yes,
Yes.
my lord, my lord.
Heard, Mr. Your good name, please.
Yobin, P. Yobin, my lord. P. Yobin, my lord.
Learned counsel for the petitioner, and also heard Mr.
and Ratan, my lord.
and Roton,
Yes, my lord.
learned counsel for respondent number, standing
One-
counsel for
one.
respondent number,
3 and 4.
respondent number 3 and 4.
1,
Mr.
3 and 4.
Kamduk,
I am for respondent number 2, my lord.
2.
Yes, ma'am.
In this In this petition under Article 226 of the Constitution of India, the petitioner has challenged the correctness or otherwise of the order dated 24/7/2024 passed by the Deputy Commissioner stroke District Collector, whereby the Deputy Commissioner stroke District Collector has rejected the representation of the petitioner for inclusion of his name in the list of affected land and assets owners. Peruse the petition and the documents placed on record, and also peruse the impugned order dated 24/7/2024. Let notice be issued to the respondents returnable in 4 weeks. 4 weeks, Mr. Ratan.
My lord,
4 weeks. 4 weeks.
4 weeks, my lord.
Step be taken by this. However, no formal notice is required to be issued since all the respondents are represented by their standing counsel. However, extra requisite copy of the petition will be furnished to them in the course of the day. Release the matter after 4 weeks.
Obliged, my lord.
Obliged, Lordship.
My lord,
Hmm.
this is a connected transfer matter. My lord, I have been transferred
Hmm.
from Boleng to Parsiparlo
Hmm.
as BDO on October 20th October 2024. And I have joined, I've submitted my joining report on 6th November 2024.
Hmm.
Now, the case is that I have released from the Boleng from the place of posting and I have joined. They are not giving me charge. This is the issue. They are not handing over me the charge to take over as transfer, as BDO. That is the issue.
Why?
It's for the authority to know as to why. Even after joining, submitting joining report, I have even written a representation to allow me to take over the charge of video, but no response come. This is the issue. Enter pack is there. Very simple.
Where is the transfer order?
Transfer order is, my lord, it is on Annexure C, Annexure B, my lord, page number 2021.
You are at serial number 1.
Yes, my lord. I'm serial number 1. I've been transferred from Boleng to Parsiparlo. And joining report is at page number 22, of which receipt copy is attached. And in this regard, I have written a representation because Deputy Commissioner is the authority to release the outgoing officer and to issue the direction for taking charge. So I have written representation to the Deputy Commissioner, Kolori and Kurukame District. That representation dated 21 November 2024 is still pending. Now it's December now. So unnecessarily lingering. So this is a sort of arbitrariness. They ought to comply the transfer order issued by the Secretary RD, the parental body, parental department.
Yes, who is for the respondent?
My lord, respondent, so many respondent, man. Anyway, my lord, what happens, suppose if transfer posting is issued, if the incumbent, my lord, does not give the handover, there is under the circular issued by the government, that immediately you should report to the issuing authority, saying that but other side not handing over the charge, my lord. So perhaps my friend, he has not reported back to the issuing authority, that is the Secretary RD, my lord.
Yes, that is
My lord, expressing my lord, the present situation. And so far, my lord, release is concerned, my lord, until and the handing over is, my lord, carried out, there cannot be release order issued by the Deputy Commissioner. That is also another problem, my lord. So, my lord, best course would have been, my lord, he should immediately report back to the Secretary, the issuing the transfer authority, saying that, my lord, the other side, my lord, officer is not handing over the charges. There are expertise charges provisionally also there, but with the consent of the issuing authority, my lord. So,
Whether any timeline is given in the transfer order.
my lord, there is no such time bar is there, my lord. There is no such time bar. My lord, usually it's happened like this. If the other side, my lord, does not give the handing over the charges, my lord, so immediately the income officer report to the issuing authority saying that the other side is not handing over. So then another order is issued to either to hand over the charge or you to take expertise charges. Expertise charges. So once expertise charges is taken, my lord, then deputy commissioner automatically issues, my lord, the releasing of the official, my lord, from the district administration. My lord. So that part, I think he has missed. Instead of coming to the Honorable High Court, my lord, he should have report back to the Secretary RD, expressing all this present situation. My lord.
No.
No,
it is
I
a
have-
way out.
My lord, I have straight away, I have.
For this purpose.
My lord, Secretary, my lord, RD, my lord,
I am the best person to answer this question, but my lord, I have not been served with a copy, my lord. Copy of the writ petition. Yes, my lord.
Survey copy.
My
We'll
lord,
take it up
definitely.
tomorrow. You
Day after
obtain it.
tomorrow, so that I can also take instruction. Day after tomorrow.
Heard Mr. Nebo, Lord and Counsel for the petitioner, and Mr.
Arash Navam, my lord,
uh,
for respondent number 1, 2, 1 to 5, I think, 1 to 5 and 8.
1, 2, 5, and 8,
Eight.
and Mr.
V picture, my lord.
Read picture.
Learned Counsel for the Standing Counsel for the respondent number
6 and 7.
6 and 7.
Yes.
The learned Standing Counsel for the respondent number 6 and 7 submits that he has not been furnished with a copy of this petition. Accordingly, it is provided that Mr. Nebo shall furnish a copy of this petition
Day itself.
today itself.
Mhm.
Today itself. Justice shall release the matter tomorrow.
Day after
In the
tomorrow.
meantime-
My lord,
Tomorrow.
day after tomorrow, my lord.
Day after tomorrow.
Yes.
My lord, tomorrow.
In the meantime, the learned standing counsel for the respondent number 6 and 7 shall obtain necessary instruction as to why the petitioner was not allowed to assume charge of the office.
Very well.
My lord, my name may be reflected in the cause list, my lord.
Yes, yes.
Registration of director.
The learned counsel, standing counsel for the respondent number 6 and 7 submits that his name is not been reflected in the cause list. Rest shall do the needful.
My lord. Okay.
Most obliged.
Number 6 and 7.
But item number 7 may be taken up. But, I am serving as on contractual basis as dental surgeon, and our recruitment were done under the centrally sponsored scheme by appearing in the selection process. And my lord, may I take your lordship to page 13, annexure 1 words. Lord, this, the government of India, the Ministry of Health, along with the government of Arunachal Pradesh, in order to boost up the health scenario, they have joined together. And State of Arunachal Pradesh has adopted a policy, that is State Health Policy 2010. Malad, at page 14, 15, 16, Malad, I have extracted the appropriate clause. Malad, page 14, Malad,
1-4.
1-4. Clause 20. It is further proposed to regularize the officers and staffs appointed under NRHM as per availability of sanction post and seniority. Now, Malad, this is only a policy decision. Now, Malad, page 17. Page 17, this is our appointment order. The Arunachal Pradesh State Health Society is pleased to appoint the following candidates to the post of GDMO, such and such, Malad,
My name appears as serial number 6.
Hmm.
And my lord, at page 19 is the combined seniority list of the contractual doctors, my lord.
Hmm.
My name appears as serial number 17
Hmm.
of the seniority list, my lord.
Yes.
Then, my lord, page 20, this is the type copy, and page 22 is the photostat copy. My lord, here, in the year 2018, 16 GDMOs were regularized.
Hmm.
My lord, from that seniority list at page 19, from serial number 1 to 16 were regularized. Now, my lord, I have given the list of the incumbents.
Hmm.
But, my lord, the sum and substance is, my lord, there were 17 vacancies in 2018. 16 were filled up, 1 was not filled up. And, my lord, at page 31, my lord, annexure 8. Look, the other these are the incumbency list, and then my representation. Well, this is the office
Page
note, my lord.
number 30,
Page 31.
31.
On my representation and request of the Honorable MP, my lord, regularization of Dr. Such and Such, a representation received from Dr. Otagu, who is working under NSM as contractual such and such since 2013, as shown below. There is 1 vacant post of dental surgeon lying vacant due to death of Dr. Late such and such dated 26/10/2015, which may be seen at flag B. My lord, these notes clearly says that this Dr. Paul, since he has demised on 26/10/2015, these vacancies were not filled up.
Hmm.
That as per official record, there are 70 no substantial posts of dental, but it is seen that there are only 69 dental surgeons are in position. Deployment list may be seen at flag D. So, my lord, it is clear that the post of Dr. Paul, who
Is
had
not
died
vacant.
were not taken, and there are still 1 vacant post.
Hmm.
So my responsible submission is, sum and substance submission is, had the 2018 regularization process had considered to fill up the entire 17 vacant post
Hmm.
instead of 16, my name, since I am at serial number 17, I would have been considered for regularization.
So those 16 were regularized in the year 2018.
18.
18.
18. My lord, you lordship may again come to page 20, annexure 4 is the regulation order. And seniority list is page 19, annexure 3. My name appears as serial number 17. And from here in the regulation order, from 1 to 16 has been regularized. But it is now clear that the vacancy was 17. So my respectful
No, no,
submission,
from which document it is clear that the vacancies are 17?
page 31, my lord. Page 31.
The 31 is a representation.
Page 31 is the file process, is a note sheet, my lord. I have submitted my representation.
Yes, yes.
File number such and such on top, my lord. Then here, a representation received such and such and such. Then here, star start 1, 2, and 3, most important. There is one vacant post of dental surgeon lying vacant due to death of late Dr. Syamal Paul, senior dental surgeon, letter number such and such dated 26/10/2015, which may be seen at flag B. Now, my lord, this Dr. Syamal Paul, he died on 26/10/2015. And the resultant vacancy has not been calculated inadvertently during that 2018 selection process. Now this number 3, my lord. As per official record available, there are 70 numbers of sanctioned posts of dental surgeon, but it is seen that there are only 69 dental surgeons are in position. Deployment list may be seen at page D, my lord. This also shows that there are still one vacancy. As per combined seniority list of GDMO, the applicant Dr. such and such is listed at serial number 17. After regulation of 17 posts by such and such, that at 31
Now,
May.
what is your prayer?
My prayer is that vacant post should be directed to be filled up in terms of the same conditions, under the same condition of 2018, my lord. My lord, in my prayer, I have categorically stated that, may I read, my lord?
No, not necessary. I have gone through it.
Regulation the
Yes,
contractual.
Mr. Tagore, what is your submission?
My lord, my submission, my respectful submission, my lord. My lord will say at page 22, my lord, regularization order, my lord. This was based on the cabinet decision dated 21/4/2017, my lord, relaxing the rule, my lord. Specific cabinet decision was taken, my lord, relaxing the rule, my lord, invoking relaxation power. Now, wherein, my lord, the specific post, sanction post was 16th only. It was against the created post or administrative exigency. 16 total. The dental surgeon was created. Against that created post, policy decision was taken to regularize the working dental surgeon under NHM, and to that effect, the policy decision was there. It is not a case of 17 vacant posts. Policy decision was taken in respect of 16 only. That if the policy decision copy, the petitioner has not annexed, my lord. In the earlier policy decision 2017, it was for the 16 only. Against the 16, all the 16 has been filled up now. During 2018, madam. Now,
No,
present
is it not your note sheet? There's a page number 31.
my lord, be that it may be, but so far the decision, my lord, policy decision is concerned. This has not been taken into consideration while taking consideration. It was never been brought, my lord. The what policy decision was taken only in respect of created post of 16 dental surgeon, my lord. This has never been taken into account. In that case, my lord, it will go to the regular, my lord, in the regular process of recruitment, my lord. In extraordinary situation, administrative exigency decision was taken only in respect of 16 posts. And this was not taken into account. When it has not been taken into account at the wisdom of the authority, my lord, ultimately this will go to the regular recruitment process, this vacant post, my lord. So, and this is the case of, my lord, 2015, my lord, assuming, my lord, now it is 2024, my lord. Now, in this connected
That
issue,
post
my
is
lord,
still lying vacant.
that, my lord,
As per this note sheet, that post is still lying vacant.
my lord, advertise has been done, my lord. Now, they have already advertised, my lord. The petitioner has challenged the advertised issued by the Public Service Commission. Now, this in connected, my lord, the case, they have filed series this connected case, my lord, up to 8, my lord. I'll just clarify, my lord. I'll just clarify.
We will come to that.
6, 7, 8, my lord. It's 6 and 7, same petitioner, my lord. Same petitioner. And the earlier case, they have not challenged this first case, they have not challenged the advertisement, my lord. Second, subsequently, they have challenged subsequent. The prayer is same, my lord. Now, 8, my lord. 8 also the same, same group, dental surgeon. Now, they are relying on order of 2021, wherein it is wherein
Have you filed your affidavit here?
Madam, we have
Yes,
we have filed an affidavit, madam. Now regarding madam, this thing, madam, this Serial number eight is important, my lord.
Hmm.
Important in the document, vital document which they've relied,
Number 8 of page number,
my lord.
you are referring to page number?
My lord,
No, we will
serial
upload
number, number 8, my lord, serial number, the act number 8, my lord.
That has not been called up, sir.
My lord, that is connected, my lord. That is why all it is connected only. Their prayer is page 46, my lord.
Yes.
Page 46, my lord. Now, page 46, my lord, the petitioner, they rely on this decision, my lord, cabinet. Now, in this case, my lord, the necessary, my lord, party is chief secretary, principal secretary, home, my lord. This is the committee, screening committee has been constituted, headed by the chief secretary. Now, these party has not, they have not been made the party, my lord. Ultimately, this is necessary, my lord. They are not proper party, only with this necessary party. Because unless this committee recognize, unless this recommends scrutiny, regulation cannot be taken place. Now, before passing any order, these party has to be made as has to be implemented, but in this case, the petitioner has not implemented. This is necessary party, without their we the conclusive decision we cannot take, How and whether this is still enforced or not, that also we don't have.
This order was issued by the chief secretary.
Yes, my lord. Whether it is enforced, whether it has been superseded, my lord. Now that the concerned authority will only, my lord, can say, my lord. That therefore, my lord, the implement of this party is very necessary, my lord. Without their say, my lord, we cannot proceed.
No, state of Arunachal Pradesh has already been made a
Made
party.
party, yes.
Party, my lord, state of Arunachal Pradesh, my lord, it is the health department, my lord. Now, so far, my lord, this part is concerned, it is done by the special screening committee headed by chief secretary, my lord.
No, whether the committee is required to be made a party here.
My
No,
lord, they are not.
because the state is in
Ma-
direction under 226.
My lord, even to say that whether the order, it is whether enforced and whether basing on this, any regulation has been done. Now, this has to be,
No, this order is issued by the chief secretary of the state.
my lord,
State is made a party here.
my lord, state, it should be
Then why
represented
the
by chief
committee is
secretary, my lord.
required
It
to
should
be
be
made
made
a
a
party here?
chief secretary, my lord. Chief secretary is not been made as a party. State should have been represented by chief secretary, my lord.
Hmm.
But chief secretary, my lord, it is not a knowledge of the chief secretary, my lord. Chief secretary is necessary party, my lord.
Now, my lord, let us complete this item number 6 and 7. No, because the basic backgrounds are slightly different.
Hmm.
My lord, in this writ petitions, this item number 6 is the subsequent writ petitions when the advertisement was issued, and by your lordship has passed an interim order protecting one seat, and then that seat is still vacant. Now, my lord, in these writ petitions, government has filed affidavit, and none of the averments has been specifically denied. My lord, order 7, order 8, rule 3, 4, and 5 are CPC is very, very clear. So denial has to be very, very specific. And 5 says if the denial is not specific, it has to be construed to have been admitted. Now, my lord, in their affidavit, in paragraph 6, my lord, page.
No, whether they have filed affidavit.
Yes, my lord, they have filed
Six.
affidavit.
In
Item
in
number
item
six.
number 6 and 7, they have filed affidavit.
Jointly.
My lord, we have taken a stand that, my lord, the post of dental surgeon, the recruitment is governed by the specific recruitment rule, statutory rules is there, my lord.
Hmm.
Wherein regulation is not a mode of appointment. Rather, it should be through competitive written examination conducted by the Arunachal Pradesh Public Service Commission. Since there's no provision regularization,
No, whether that
And-
rule was followed in case of the other 16.
Yes.
other case, Maluk, there was a specific policy decision mentioning particular post created, Maluk. That was there, Maluk. But in this case, Maluk, no such policy
Maluk,
decision was taken. Maluk.
Therefore,
When-
Malad, let us read paragraph 6, Malad,
Hmm.
of their affidavit in item number 7. Of respondent number 1 and 2. Paragraph 6, Malad.
Yes.
Malad, may I read, Malad?
Hmm.
That the regulation of 16 dental surgeon by order number such and such 31/5/2018 was done on the basis of state cabinet decision adopting one-time relaxation for regularization of serving dental surgeon under NRHM by relaxing the Arunachal Pradesh Health Service Rules 2000 by invoking Rule 16 of the said rules. Thus, without relaxing the rule by way of specific policy decision for regularization of contractual staff, including the dental surgeon, is beyond the scope and jurisdiction of the respondent authorities. Now, my lord, here there are two aspects, my lord. First thing is that the cabinet decision has never decided that only 16 posts has to be regularized. This cabinet has decided that on the basis of availability of the post and seniority, the GDMO dental surgeon should be regularized. They have never specified that it should be only limited to 16.
But,
Secondly,
that cabinet decision is available.
cabinet
Maluk,
decision
it's not there.
is not.
We can bring on record, Maluk. It's only it clearly indicated the 16 post, Maluk, of dental surgeon in the cabinet decision itself, Maluk, in 2017's cabinet decision. It's not been brought on record, Maluk.
Then, Malad, thus, without relaxing the rule, by way of specific policy decision, Malad, this, your lordship has always can direct that they should relax the rule as was done.
Maluk, that
the
cannot
same-
be done.
same-
It is
Similarly
the freedom of authority, Maluk.
situated.
That is beyond the scope of the writ jurisdiction, Maluk. So
See-
for directing of how and what manner policy decision is taken and what law, the law is to be amendment, what law is to be enacted. This is the beyond the purview of the writ court, Maluk. With my respectful humble submission.
My lord, they have filed their affidavit in item number 6 and 7. In none of this affidavit, they have taken a stand that these specific 16 posts were directed to be regularized by the cabinet. Had it been, I would have challenged that decision.
We
How
can
can
bring
they,
it to record.
We bring on record.
Maluk,
that
we can
there's
bring
a
it to
cabinet
record,
decision.
Maluk. Regarding that is what specifically 16 posts was mentioned, Maluk, in the policy decision. That I can bring on record.
So on day after tomorrow,
Yes, my lord.
On Friday, Maluk.
Not on Friday, my lord. Day after tomorrow.
On Friday, Maluk.
Friday,
Yes, ma'am.
why not day after tomorrow?
Yes. Maluk,
Or
Friday, let it be
Friday,
Friday, Maluk, Friday, because
Maluk,
I have to,
Friday.
for swearing,
Let it
Maluk,
be on Thursday, my lord, then.
Maluk, let it be on Friday, Maluk, on 6 only. Today's, Maluk,
No, only you have to
five,
bring
let it
on
be five.
record
Let it
the
be five.
decision of
Yeah,
the cabinet,
Five,
nothing else.
Maluk. Then let it be on 5, Maluk.
No,
Fine.
to be in safe side, let it be day after tomorrow, so that we get some more.
Madam, let it be
time.
5, Madam. Madam, I'll make sure that, Madam, it is filed in time, Madam. That's why, Madam. Let it be 5, Madam.
Also,
On Thursday, Madam.
Mr. Tagum, learned standing counsel for respondent number, you are for respondent number
1 and 2.
1 and 2.
Madam.
And for rest of the respondents? Oh, there are only 2 respondents.
Yes.
Resistor leaves the matter on Friday, so as to enable Mr. Ragam to produce. No, to bring on record the decision of the cabinet. Taken on
17, my lord. It was 2007.
In the year-
17.
Yes.
In respect of regularization of 16
16
numbers of dental
That
surgeons.
was my.
By filing, no, by way of, by filing an additional appeal.
Deeply obliged.
On
In all
Thursday.
the three matters,
My lord, my lord,
seven,
my lord, my lord.
No, my lord,
seven and
here-
eight. 6, 7 and 8.
My lord. Your dental, 8 is also dental, my lord, connected, my lord. Same, my lord.
Here, my lord, this is, no regulation process was taken up for this post. Now, on the basis of the, since the, as, my learned friend has said, this, page number 46, this order committee, since they are duty bound to consider regularization, question of regularization as on that day. My lord, now they are bound to consider as on that day only. They have not taken any stand. Those aspects also will come. My lord, let it be on Thursday then, my lord, all these cases.
Thursday or Friday?
Friday.
Thursday, madam. My lord, Friday I have one personal issue.
Okay, Thursday.
Lordship, similar connected matter, Lordship, writ petition 391 can also be tagged along,
Is it listed today?
not listed.
No,
So
you
why
have
I'm
mentioned it.
requesting for accommodation, Lordship. Can it be tagged along with this matter, same connected matter, Lordship? Issue is same. Can we dispose of it?
On the appeal being made by Mr.
J. Gini, Lordship.
Learned counsel for the petition, SSL also take WBC number
391, Lordship.
391 of 2024 along with this writ petitions.
All right.
Your Lordship, by this writ petition, petitioner is assigning the order dated 5/9/2024, Your Lordship, whereby the petitioner has been ceased to perform as the Gram Pradhan in gross violation of section 63 clause 3 of the Panchayat Raj Act. The brief fact of the case is that petitioner has been selected as the Gram Pradhan of 4/8 Wag Ragi. By taking to the annexer, Your Lordship, annexer 35. May I please? Annexer 1, page number 35. Petitioner was initially appointed as the Gram Panchayat member from 4/8/3 Wakragi. And accordingly, Your Lordship, the 4/8 Wakragi is a reserved seat for woman quota. And accordingly, the petitioner, being the only woman Gram Pradhan in the Wakragi, has been elected as the Gram Pradhan. So Lordship, find page number 37, Your Lordship. Serial number 174. Page number 37, serial number 174. So Your Lordship, there are 4 Gram Panchayat members in Wakragi, and petitioner is the only female Gram Pradhan member, and therefore she has been elected as the Gram Pradhan. Thereafter, the petitioner has performed his duty with utmost sincerity and dedication and helped the government agencies to execute the and implement the government activities in the said village. However, to the aftershock, complaint has been filed by the other 3 Gram members, male Gram members, before the neighbor secretary. Your Lordship will find it page number 41, Your Lordship. Annexure to page number 41. May I read, Your Lordship?
Yes.
Complaint against Srimati Moham Kamgo, GPC, for misappropriation of SOR scheme With reference to the subject cited above, we the understand would like to state the following few words for your kind consideration and necessary action. That said, it is learned from reliable sources that SOR scheme, SOR against Wak Ragi delays for financial year 2022 of slash 2023 has been executed by Sri Lipa Kamgo, husband of Sri Mongam Kamgo, DPC, 2 times without conducting Gram Sabha in the village and without the knowledge of the undersigned. If Gram Sabha minus of said vote is submitted to this office, it will be forgery 1. You sincerely, Mubin Kamye, GPM segment 4, Gamo Alter, GPM segment 2, and Sri Jumna Sora, GPM segment 1. These are the Gram Panchayat members who has lodged complaint against the petitioner. Accordingly, you also will find page number 43, the explanation letter pulled by the member secretary. Page number 43. Please find here with the complaint letter against you from the GPM members of Wak Ragi. Instead of kindly furnish an explanation letter for the same within 5 days. Accordingly, the petitioner has submitted his explanation letter, reply letter. So you will find it page number 44 and it's pre-filled. Thereafter, what happened, you will see, after submission of this reply for the explanation letter called by the member secretary, the private respondent have filed again a complaint before the head Gaugura of the said village. You also will find it page number 46. This is the complaint lodged by the private respondent before the head Gaugura. Complaint against Srimati Mona Kamgo GPC and his husband Sri Lirpa Kamgo for misappropriation of SOR scheme. Then after what happened, Your Lordship, I have filed my representation before the head Gaugura. Your Lordship will find it page number 48, Your Lordship, in Exhibit 4 series. Here I have mentioned that matter is already pending before the member secretary. They have filed complaint before me, Your Lordship, before the member secretary. So I have submitted my representation before the head of Gura stating that the matter is subjudice, so not to conduct any kaba in response to the complaint dated 8/7/2024 submitted by the private respondent. Thereafter, Your Lordship, what happened? The kaba was not conducted. Then again, at page number 49, Your Lordship, in Exhibit 5, they have submitted notice of intention to move no confidence motion against me, Your Lordship. Your Lordship will find it page number 49 in Exhibit 5. Yes. This is their notice of intention. Accordingly, Your Lordship, notice was issued and hearing was fixed on 5 September 2024. Your Lordship will find a page number 51. Type copy is page number 52. Issued by the member secretary. Meeting was fixed on 5 September 2024. However, Your Lordship, I could not attend the said meeting, and accordingly I have filed an application for extension of the date of hearing, which has been fixed on 5th September. Your Lordship will find it page number 53 in Exhibit 7, Your Lordship. I have submitted my application stating that I am on medical treatment. Therefore, I could not attend that hearing date, which has been fixed on 5th September. However, my application was not entertained, and accordingly, Your Lordship will find the impugn order is in page number 59, Your Lordship. And Exhibit 8, Your Lordship. Page number 59. Impugn order. Yes. In pursuance to the hearing notice issued by order number WS/RAG/ELN/2024 that is allowed 18 August 2024, the hearing for no confidence motion of GPC 4/8 Wakragi GPC of 4/8 Wakragi was conducted on 5th September in the office chamber of member secretary allowed 10:20 hours. The no confidence motion was moved by Sri Mubin Kamni, GPM 484 Wakragi, Sri Vermo Author, GPM 4/8/2 Wakragi, and Sri Junya Sora, GPM 4/8/1 Wakragi, in accordance with section 63 clause 1 of the Arunachal Pradesh Panchayat Raj Manual 2018. The list of attendance is appended overly. Following member attended the hearing process: Sri Iken Bang, Member Secretary; Sri Mubin Kamni, GPM Wakragi; Gamu Atta, Jumna Sora. Your Lordship, I was not present in this hearing process, and they have passed this impugned order in
Without
my.
hearing you,
Your
without hearing you.
Yes, Your Lordship. And thereby they have violated the provision of section 63 clause 3 of the Panchayat Raj
63?
clause 3. May I read? 63 clause 3. Notwithstanding anything contained in this act, the chairperson of a Gram Panchayat or Jila Parishad shall not be preside at a meeting in which a motion of no confidence against him is under discussion, but he shall have the right to speak or otherwise take part in the proceeding of such meeting. Your Lordship, the impugned order has been.
But they have given notice to you, you failed to appear.
Yes, Lordship. But Your Lordship, I have submitted my representation stating that I was on medical treatment. So I just paid for the extension of the said meeting. And this provision is specific.
Whether you have enclosed any medical.
Yes, Your Lordship. I have annexed medical document along with my representation, Your Lordship.
Your representation is at page number
My representation is page number 53 onwards, Your Lordship.
53, and medical document?
Is 55 onwards, Your Lordship. 55 to 58, Your Lordship. Your Lordship, one more thing, Your Lordship. Even if I would be terminated from my post of Gram Pradhan, then Your Lordship, the village will remain without any Gram Pradhan because the seat is reserved for the woman Puta. And I'm the only one who is woman Gram Pradhan member. And being only woman, I have been elected as the Gram Pradhan, Your Lordship. If I would be terminated, then the village will remain without any Gram Pradhan, and many developmental activities of the said village will be hampered, Your Lordship, and ultimate sufferer will be the village people, Your Lordship. The first thing they ought to have, Your Lordship, hear me, and ought to have made me a member of the proceeding. They have violated this provision, Your Lordship, and thereby violate the principle of natural justice. So I humbly pray that this impugned order may be quashed and set aside.
Yes, Mr. Tapin?
Consequently, page 52, this is notice. In this case, also, what I understood is whether the statutory requirement given in the Panchayat Raj Act has been complied or not. This part only has to be seen by the. Here also on 16 August, there are 4 members in this particular constituency also, in this particular invitations. And out of 4, also 3 have moved against her. And notice has been issued on 16 August 2024 at page 52 lawsuit.
Hmm.
And no competent motion has been fixed on 5th of lawsuit September. And what is the statutory requirement? Lawsuit? There's 7 days, at least minimum 7 days. Here more than lawsuit, 18 days has been given lawsuit
Hmm.
in this particular. Because notice is of 16 August and the no competent motion has been fixed on 5th of September.
But she was suffering from some ailments.
Lawsuit whether
So as per this page number 55, 56, 57.
out of this lawsuit, nothing could be lawsuit nothing could be lawsuit found of that he is in such a position that he cannot attend the lawsuit. Otherwise, this is excuse lawsuit. This ground would substitute the statutory provision, which is not permissible. If lawsuit see the report says lawsuit impression, no lawsuit obvious, no any abnormality has been found. It page 56 lawsuit.
Hmm.
This is the LA ultrasound report. Down below impression, no abnormality seen lawsuit. And page 55 also, what exactly lawsuit it says. We can't read lawsuit.
Hmm.
And in his lawsuit representation, that's page 53 lawsuit.
Hmm.
He said lawsuit at paragraph 2, that is page 54 lawsuit, the last paragraph. I'm leaving for my further treatment to Itanagar by 3rd September 2024. I'm unable to attend the said hearing, which is fixed on. After lawsuit, on 3rd September, whether he moved to Itanagar or not, lawsuit. That part is silence here in this petition.
Hmm.
He said on 3rd he is moving to Itanagar, he won't be available there at Alo. So therefore he wouldn't be
No,
able to.
but there is a requirement of hearing her as per this 63 subsection 3.
Here lawsuit, right to participate is their lawsuit.
Hmm.
Whether he participate or not, that is up to her lawsuit.
Hmm.
The statutory requirement lawsuit, at least minimum of 7 days notice has to be given. That has been done here in this case. Otherwise, lawsuit, in his way lawsuit, this particular adjournment or extension is permissible lawsuit. Then lawsuit, he will keep lawsuit extending the meeting, and it will amount to sufficient of his power by this very lawsuit ground taken by the petitioner. We need to repeat the provision itself also. If we can, inference can be drawn from the record, he was admitted in hospital, for example. We can understand also he is not at all also in position to attend the meeting.
Hmm.
But nothing is there.
No, as per this representation, she left for Itanagar for treatment. This representation.
Therefore, also, whether he moved to Itanagar or not, also, all those are not here. At page 54, we said he will be moving to Itanagar on 3rd September.
Hmm.
And this writ petition has been filed on 30th September,
Hmm.
after 28 days. But what had happened after 3rd September, whether he moved to Itanagar for further treatment or not, all those are not here on record.
But there's medical documents are there. It shows that she was suffering from some ailments.
They
Hmm.
But what I'm pointing out, one is the statutory part. Law.
Hmm.
Otherwise,
No, this,
this
60
way,
day
adjournment
ethics.
petition is filed, lawsuit. It will defeat the very provision law. So for right to lawsuit to be heard lawsuit, that is real lawsuit. We can participate. We are not debarring him. Suppose say any action debarring him from participation lawsuit. Then lawsuit we can understand lawsuit. What it says, 63 lawsuit.
Hmm.
Then it says she has a right to be heard lawsuit.
Hmm.
She
She has not been heard.
We are not doing anything to debar him from hearing also. He herself, she is not appearing.
No, that's all right, but she has a reason to not appear.
Yes. And that reason was it for anything on the request was that at all she was not in position to attend.
Hmm.
If that sort of document is there also, then also I have nothing to say. Nothing is there also that she is at all not physically fit to present in the meeting. That part is missing also. Why my only lawsuit, only second lawsuit is only suppose say this is allowed law. Then on next meeting also again he will be filing an application lawsuit. He is at Guwahati.
No, we'll only give one chance. We'll fix a date. She will appear. You hear her. And thereafter take a decision on whatever
And
you
why
want.
this is very dangerous lawsuit?
Why?
Because lawsuit in any lawsuit no confident motion also.
Hmm.
The person against whom it's proposed lawsuit.
Hmm.
He can file this sort of application and it will be getting
No,
accepted.
no.
And this decision also it will be a precedent for all those lawsuits.
No.
Like you lawsuit.
No. So, since this decision is taken without giving her an opportunity of being heard, so this impugn order failed to withstand the legal scrutiny.
Well, opportunity was given, sufficient opportunity was given,
No,
but
no,
she was not lawsuit present due to her own grounds. One thing is opportunity is not given lawsuit. We have given, but there's a difficulty on her part that she could not appear. This is her case.
Hmm.
Suppose say if we have not given the notice and all, and this no complaint has motion has been conducted, then it can be said that no opportunity was given. These two part concept is having two phases.
So, give her one chance to defend her. Hmm?
And apart from that, one more submission was
Hmm.
out of 4 lawsuits, private respondents are here lawsuit.
Hmm.
3 are against her. Even if press chance is given also lawsuit, future exercise only lawsuit.
Maybe.
But
Maybe.
Supreme Court lawsuit, when apparently lawsuit it will be like unnecessary exercise. lawsuit.
No. Whatever be the outcome, you give her a chance.
Then I'm living up. It's no good lawsuit.
Hmm. Yes, anything?
Yes, Lordship. Lordship, as the senior government council has rightly pointed out, there is no violation of any provisions. In fact, opportunity was given to her,
Hmm.
but it was her who herself decided not to present on that meeting day.
Hmm.
In any case, Lordship, if my Lordship, on a view to give her one opportunity, it should be with strict terms and conditions that on that day, she must present the meeting.
Oh. Yes, suggested it.
There will be no any excuses, other excuses.
When?
Let the competent authority.
Pardon?
Competent authority choose the date, Your Lordship. For the hearing.
Competent authority.
Yes, Your Lordship.
Lordship, what if after passing of interim order by this honorable court
Hmm.
on
There is interim order.
110, yes,
Yes, yes.
interim order was passed.
Yeah.
Thereafter, Lordship, in the interim order, it is clearly provided that the pendency of this writ petition shall not be a bar to the member secretary to conduct a fresh no confidence meeting by issuing a proper notice to the petitioner. Thereafter, Lordship, on
Whether this order was executed or carried out, direction given in this order.
Lordship, after this interim order,
Hmm.
with the private respondent number, all this private respondent number 3, they have filed fresh representation before the member secretary on 25th October. But that has not been acted upon by the member secretary on the ground that since the writ petition is pending before the High Court. So Lordship, in that case, direction may be issued to the competent member secretary to issue a fresh no confidence motion notice by giving 7 days statutory time. And direction may be issued to the petitioners on the event of receipt of that press notice. She must attend without any further excuses. That will suffice.
Pardon, Mr.
I want.
Learned Counsel for the petitioner, and Mr. Tapin. Learned Senior Government Advocate for the respondent number, and Mr. Nolan for respondent number
567.
567. Correctness or otherwise of the order dated no, not order. A minutes of the meeting dated 5th of September 2024 is challenged in this petition under Article 226 of the Constitution of India. It is to be noted here that by impugned minutes of meeting dated 5th of September 2024. All the three ZPMs present in the meeting voted to remove the chairperson, Srimati Mongam Kamgo, the petitioner hearing. The learned counsel for the petitioner submits that the petitioner was selected or elected? Elected as one of the Gram Panchayat member, within bracket ZPM hereinafter of 4/8 Wakragi Alo West Panchayat segment, West Siang district Alo. As the only female member, female GPM, amongst others, 3 male GPM of Wakragi. While she was discharging her duties as GPM, the private respondent herein lodged some false complaint against the present petitioner, and thereafter notice of intention to move no confidence motion against the petitioner was given on 16/8/2024, which was submitted before the member secretary dated the member secretary 38 Alo West Panchayat Raj, West Siang District. Thereafter, the private respondents in their notice dated 16/8/2024 alleged that the petitioner has no cordial relation with other Gram Panchayat members. The within bracket, the private respondents herein and adversely affected the work culture of the Panchayati Raj system of 4/8 Wakragi Gram Panchayat segment. And pursuant to the notice of no confidence motion dated 16/8/2024, moved by the private respondents against the petitioner, the member secretary, White, notice dated 16/8/2024, number WS/RAG/ELN/2024. Fixed the date of hearing of no confidence motion on 16/8/2024. Moved by the private respondents against the petitioner to be heard on 5/9/2024. The learned counsel for the petitioner submits that the petitioner could not remain present in the said hearing as she was under medical treatment. And she left for Itanagar on 3rd September 2024 for further medical treatment. And she had submitted one representation on 3/8/2024 to the member secretary for extension of the date of hearing, which was scheduled on 5/9/2024. But the same has not been entertained and to the utter shock and dismay of the petitioner, the circle officer cum member secretary 38 Alo West Panchayat segment has illegally and arbitrarily passed the impugned order number WS stroke RAG stroke ELN stroke 2024 stroke 260-65 dated 5/9/2024, whereby the petitioner has been seized to perform as Gram chairperson of 4/8 Ward Ragi West Siang District Alo in violation to section 63 within bracket 3 of Arunachal Pradesh Panchayati Raj Act 1997 and in contravention to the principle of natural justice. The learned counsel for the petitioner therefore contended to allow this petition by setting aside the impugned minutes of the meeting dated 5th of September 2024. Mr. Kapil, learned senior government advocate for the respondent number so and so, however, submits that the petitioner was given the notice before conducting the hearing on 5th of September 2024. But the petitioner remained absent And though some medical documents were enclosed with her representation, which she had filed for extension of time, the said documents does not indicate that she was suffering from any ailments, and she has preferred this writ petition after how many days, Mr. Tapin? After how many days this writ petition was filed after passing the impugned minutes of meeting?
This, it was filed on 13th September.
25 already. 30th September 2024. And there is no document to suggest that she has left for further treatment at Itanagar. And that no provision of the Panchayati Raj Act has been violated by the private respondents, no, by the respondents hearing, and therefore Mr. Kapin contented to dismiss the petition. Mr. Lolan, learned counsel for the private respondent, also adopted the submission so advanced by Mr. Tapin, learned senior government advocate. But having heard the submission of learned advocates of both the parties, I have carefully gone to the petition and the documents placed on record, and also perused the minutes of meeting dated 5th of September 2024. It appears that on 5th of September 2024, the petitioner remained absent. Further, it appears from the documents placed on record that she had filed on representation for extension of date of hearing, including some medical documents, but the same has not been considered by the authority, by the respondent authority. And without giving her a chance, the respondent authority has passed the minutes of the meeting dated 5th of September 2024, removing the petitioner from the post of chairperson. Section 63 of the Arunachal Pradesh Panchayati Raj Act 1997 provides for motion of no confidence. And subsection 3 to the said section provides that notwithstanding anything contained in this act, the chairperson of a Gram Panchayat or Jilla Parishad shall not preside at a meeting in which a motion of no confidence against him is under discussion, but he shall have the right to speak or otherwise take part in the proceeding of such meeting. Admittedly, in the present case, the petitioner was not given an opportunity of being heard as she remained absent on that day on account of medical urgency. Thus, having examined the impugned minutes of meeting in the light of the given facts and circumstances on the record, and also in the light of submission of learned advocates of both sides, as well as taking note of the provision of subsection 3 to section 63 of the Arunachal Pradesh Panchayati Raj Act. This part is of the considered opinion that the impugned minutes of meeting fails to withstand the legal scrutiny, and accordingly the same is then set aside and quashed. The respondent authorities are directed to refix a date for hearing When can it be fixed? Suggested.
A minimum by giving notice, minimum of 7 days. The authority will fix the date.
Authority will fix.
We also may observe the minimum notice of 7 days is prescribed under the law.
The respondent authorities shall give press notice to the petitioner, giving minimum 7 days time. And the petitioner shall appear before the respondent authorities on that day without fail. The respondent authorities shall also give notice to the private respondent person to the in view of the order dated interim order passed by this court on 1/10/2024. In terms of this writ petition instance disposal.
Please, my lord. My lord, in this matter, I have instruction from my client not to press any further. Matter being all one 2019 matter. I may be allowed to withdraw the matter, my lord.
You want to withdraw this?
Yes, madam.
Fresh elections have also been held, my lord. And
Pardon?
fresh election has also been held, my lord. The assembly, last legislative assembly, it was dissolved and fresh election was also held this year, 2024.
Lord Mr. Ladin, learned counsel for the petitioner. Mr. Ladin submits that he has instruction to withdraw this petition. Where is according to law. But that matter. Accordingly, this petition stands disposed of on withdrawal.
Yes. Most obliged.
In view of order passed in item number so, there's IA number 37 and 227 also stands disposed of.
Most
Obliged.
Item number 12.
My lord, item 12, there is an interim order now. This matter has lingered because initially there was an understanding that the petitioner is going to withdraw, but they have not.
Petitioner.
Thank you.
Might be your lordship.
Yes,
My lord, I'm appealing for the petitioner.
yes.
My lord, in this case, it is true that, my lord, in the month of March, there was an interim order that the tender process should not be completed without the leave of the Honorable Court. And the matter is in a very short campus. What has happened in this case, my lord? There were only two bidders. The work is of infrastructure development of government secondary school in Combine Alo, my lord. Two entities submitted tender, including the writ petitioner. In the technical bid, both have been found responsive, but in the financial bid, my lord, the other bidder's bid was found to be not in accordance with the CBC guidelines, so it was rejected. So far as the petitioner is concerned, he is the only entity left in the entire fray, my lord. And if your lordship goes to the scrutiny of the financial bid, they have mentioned that the total value of the work was 10.47 crore. And the petitioner has quoted a price of 9 point something. So they say that your bid is lower by 14%. And so far as financial bid is concerned, if your lordship goes to page 168,
$160.
Once it starts from 168, my lord. 168.
Yes.
My lord, if it is the report of the committee, and it has been mentioned to be a financial scrutiny. Next page, my lord, in one line they have concluded, page 169. From the above, it is revealed that the rates adopted by Messrs. TJ Enterprises, that is the writ petitioner, my lord, is not justified and not acceptable. The other firm, Messrs. T. Gangkek Enterprises, is also not acceptable due to CVC guidelines. My lord, our instruction is that so far as the Gangkek Enterprises is concerned, their tender having been found to be not in conformity with the CVC guidelines, it had to be rejected. And after rejection, my lord, they are not interested to award the work to the writ petitioner. So they have mentioned that it is not justified, not acceptable. And so far as the affidavit is concerned, my lord, the government has filed an affidavit. That affidavit, if your lordship goes to paragraph 9 and 12 of their affidavit, my lord, in the running page, it will be 145 and 146, my lord.
Yes.
Well, in paragraph 9, they have mentioned that with regard to the statement made in paragraph 12 of the writ petition, the answering respondent begs to state that the petitioner has quoted 14% below the tendered amount. And major items like internal electrification and carrying items has been drastically varied from the approved cost and specification. And the next page, my lord, just next page, para 12. That with regard to the statement made in paragraph 15 of the writ petition, the answering respondent begs to state that during the evaluation of the price bids, the price quoted by the petitioner was only considered. Hence, there were not any role of the second lowest bidder. Further, due to unjustified and non-responsive rates quoted by the petitioner, the scrutiny committee recommended for retender. Now, the scrutiny committee has recommended for retender, which I have challenged, my lord, before your lordship. Now, if your lordship, my lord, I'm just indicating, my lord, I'm actually inclined to argue this case physically with your lordship. If your lordship gives us just 1 week's time, next week, 11th, I'm intending to go and physically argue the case before your lordship.
Okay, all right.
Subject to what my learned friend appearing for the state learned additional AG says, my lord.
Yes.
My lord,
I know
in
there is
fact,
urgency.
there, after the filing of this writ petition, there was another tender floated, my lord. And by the interim order of this honorable court, the petitioner was directed to participate, my lord, asked to participate. He did not participate in the subsequent tender. If my lord-
Petitioner is confident that his writ petition will be allowed, so that is why he did not intend to participate in the.
My lord
process.
will kindly see the order dated 12/3/2024.
Well,
12/3/2024.
yes.
From the third paragraph, my lord,
Mm.
it is seen that the respondents have on cancellation of earlier tender process issued a fresh bid on 4/3/2024, and the last date for submission of the bid as stated in the bar is dated 18/3/2024. The petitioner is granted leave to submit his bid in pursuant to the NIT dated 4/3/2024. However, the respondents on receipt of the bids in pursuant to the NIT dated so-and-so shall process the same. However, the financial bid of the bidders in pursuant to the NIT dated so-and-so shall not be opened without the leave of this honorable court. My lord, Meaning thereby there was no stay in this, my lord. Petitioner was allowed to participate in the subsequent tender, my lord. He has not participated, my lord.
My learned friend is correct, my lord, leave has been granted, but then at the same time, my lord, the writ petition is
Now,
alive.
because
Just 1 minute, my lord, my writ petition is alive. The order itself says, my lord, towards the end. However, the correspondence on receipt of the bids in pursuance of NIC so shall proceed the same. However, the financial bids of the bidders in pursuance of the NIT dated 4/3/2024 shall not be opened without the leave of the Supreme Court, leaves this matter again on Spencer. So this matter is required to be heard. My lord, I'm intending to go and I can argue, my lord, but then it's better that I go physically and argue the case before your lordship on 11th. This 1 week, my learned friend possibly can wait. And on that day, your lordship will take it. Your lordship is sitting in the next week. Lordship will take it up for final disposal.
we are fearing that the fund might lapse, my lord, because of the
My lord,
pendency.
it's a matter of 1 way, and today it has
Because,
come up for orders, my
The
lord.
main issue is whether the petitioner and the bidder, as a matter of right, can ask for accepting of his bid, my lord, which is as per the tender evaluation committee, and the variation is too high, my lord. So whether he, as a matter of right, can claim for accepting his bid, my lord. That is the only legal. Otherwise, we are unjustified rates. Whether his unjustified rate can be
What for
accepted.
11? Heard Mr. D. Mazumdar, learned senior counsel assisted by Mr.
SK Devi, ma'am, he's yes, ma'am, he's there.
Learned counsel for the petitioner and Mr. Henry Rotten, learned counsel, standing counsel for the respondent number.
My lord, 1, 1, 2, 5. 1 to
1,
5.
2, 5, and Mr. Tagum,
And for respondent number, private respondent 6.
respondent number 6. Place the matter on 11th.
My lord,
For
I'm
final
deeply offended. And let it come up for admission because today it has come up for orders.
Okay, admission hearing.
My lord, deeply obliged.
Obliged, my lord.
May it please your Honor. Your Lordship, this matter pertains to the transfer issues, item 13, Your Lordship.
So this IA is for what purpose?
IA is for Your Lordship, when the matter came up for motion on that day, Your Lordship, the interim prayer was neither rejected nor granted, Your Lordship. So because of which even appellate forum, I'm deprived to go to the appellate forum in the event because interlocutory application is yet to be decided, interlocutory prayer. So IA civil was filed, Your Lordship. And on this matter, Your Lordship, today was fixed for hearing. And the other side, that is respondent number 3, was supposed to file affidavit, Your Lordship, without any further adjournment, Your Lordship.
Who is for respondent?
Respondent number 2 is senior government advocate. He has already filed the affidavit on behalf of respondent number 2. Respondent number 3 prayed for filing affidavit, Your Lordship. In main writ petition. Your Lordship,
My lord, it appears that the step has not been taken against the private respondent in the main writ petition, madam. This the step is still the report is still awaited, madam, in respect of main writ petition in respect of private respondent.
Nipen Roy.
Your lordship, we have filed, it's on 11/11/24 order, your lordship. We have already submitted, the direction was given for serving notice through dusty mode. So we have already served that way and even submitted our affidavit to that effect on the last date itself, your lordship. It is reflected in 11/11/24 order, your lordship.
Yes, Mr. Tagum. So notice was served upon on respondent number 5.
Right, my lord. In that case, my lord, but I was informed, my lord, in the main writ petition, my lord, the service is not to be awaited.
The affidavit is ample clear, your lordship, the copies of writ petition as well as the copies of interlocutory application, both are served together, your lordship. And that is sworn in the affidavit, your lordship. Since your lordship,
Whether you have filed a affidavit in opposition?
Lordship, already on 1st October already.
Filed.
Yes, sir.
And
For
Mr.
1,
Tagum,
2 and
you-
4.
You have filed.
And I'm not fine, but I'll go by the affidavit of the.
Acha. Acha. So can we hear the matter today?
yes, your lordship, it can be heard because on 2 occasions also, your lordship, the direction was very much specific to file the affidavit, your lordship. In 25/10/24.
Taken up subject to what regarding the private respondent. Private. Otherwise, we don't have.
Because
any
it's a
objection.
transfer matter, otherwise it would turn infructuous, your lordship, without
Otherwise,
being
the
decided
petitioner
on
is
merit, your
already
lordship.
working there, Lordship, where he has been posted, Lordship.
That order is paid?
So he is already working there in DMO office.
No,
Sorry,
no,
This is
no, I haven't joined, your lordship. Still, I haven't joined.
Join naked.
correct. Otherwise, matter can be taken up. Lordship.
Can be taken up. But it is listed in the order column today. In the copies.
No, can I? Orders.
This for admission.
Otherwise, maybe list for admission also. Since my friend, he want to rely on the affidavit filed by me also. And he is not going to file affidavit. That may be recorded and matter may be fixed for admission hearing also. On that day, it can be disposed of. And regarding private respondent also, Lordship may make some observation whether.
No,
Yeah.
already there is an observation. Order dated 11/11/25.
11/11/24.
Okay.
Your lordship, otherwise the matter may be fixed for admission, but a short date may be given since your lordship by
Day after tomorrow?
day after tomorrow.
Yeah.
Yes, your lordship.
Heard, Mr. Your good name?
And Sharma, your lordship.
And Sharma. You are from Guwahati?
No, your lordship, from Tinsukia, your lordship.
Acha. Learned counsel for the petitioner. And also heard Mr. Stopping, learned senior government advocate, with a respondent number 1 and 2. Then Mr. Tagum, for respondent number 3. None appears for the respondent number 5. Though service was effected upon him by Dustin. Mr. Tapin, learned senior government advocate, submits that he has already filed his affidavit. And Mr. Tagum, learned counsel for the respondent number 3, submits that he will not separately file, he will not file affidavit in opposition separately, then he will rely upon the affidavit submitted by respondent number 1 and 2. In view of above, it is provided that rest shall raise the matter day after tomorrow for admission hearing.
Deeply honest.
May it please your lordship.
Yes.
So the dispute has otherwise come down to a very small issue now. This was otherwise a tender under the power department for erection of these poles as well as those wires. Now I was found to be L1. However, by the order, my tender, my bid was rejected on the ground that it was abnormally low. So I challenged that before this honorable court. Pursuant to the notice, the department came up with a notification that they will review the entire situation, the entire order. Now that notification, your lordship will find as Annexure X here. Now, based on that review, a report has also now come. They constituted an independent committee, 3-member committee. The 3-member committee looked into the market rates vis-a-vis the rate that I had quoted. And pursuant to thereof, now their report says, page 10, which is a part of the records now, that my rate is in fact 17% higher than the market rates. So it is very much workable. It cannot be abnormally low. So in that view of the situation, the only thing that is left before this honorable court is to set aside the impugned order and direct them to award the contract to me. If your lordship will kindly see that report.
So why the matter is listed today in the order?
The difficulty is this committee was established in the month of May 2024.
No. My question is why the matter is listed today?
If you will see the order dated 4/10/2024, 4/10/2024, the second last order, a direction was given to the respondents to pass appropriate orders based on the report. But it seems that the government is failing for 2 months now to pass any order. So therefore, I seek before this honorable court that the order has to be passed by this court. The opportunity was given to them that the report is there. The report says that your decision taken by your tender evaluation committee is wrong. The rate that you had rejected as unworkable because of abnormally being low, your committee says it is perfect, it is workable. In fact, it's 17% higher than the market rates. So the honorable court have therefore directed the power department to take a call and pass appropriate orders based on that report, that is Annexure X. Now, four weeks time was given to them. They failed to pass any order. Next date, they appeared, another 2 weeks time they have taken. Today, they will be taking another time. So therefore, it indicates that they are not very much sure as to whether they will be acting on that report or not. And there may be some mischief that may happen because of this delay. Tomorrow, they may come, they say, no, we are going for some another report or something. That opportunity should not be allowed to them. What is now therefore reveals is that the impugned order was perverse. I was L1, lordship. I was L1. They rejected me saying your rate is abnormally low. Then I approached the honorable court. I stated that no, this rate cannot be abnormally low. I have produced all those documents to indicate the market rate and everything. Notice was issued. The government next date says we are revisiting. We are constituting a new committee, their own committee of independent members, 3-member committee. The committee, therefore, thereafter looked into that evaluation. Again, that committee now gives a report that it is not abnormally low. The report is in my favor. It is not abnormally low. In fact, after looking at the market rates and the rate given by the bidder, it is found the rate of the bidder is 17% higher than the market rates. So if that is their report placed before this honorable court, what remains now? It therefore indicates that the impugned order of rejecting me was an unreasonable order. So it has to be set aside, lordship. But your lordships had given them a chance to pass an order on their own based on the report. But they are not doing it for 2 months now. I have my apprehension. Tomorrow they will be playing and coming before the honorable court saying that we have taken this decision, that decision.
Yes, Mr. Parme.
So,
Lord, we are seriously on the report, my lord, and we are playing some more time, my lord.
that's what is
Now, my
happening,
lord,
lordship. I have my apprehensions on this.
Why you are praying for more time?
My lord, the earlier occasion, my lord, the concerned respondent, my lord, was out of station, my lord. Last week, my lord, I personally have a meeting with the concerned my lord. He asked me to pass the necessary order within 2 or 3 weeks, my lord. Now,
2 or 3 weeks.
3 weeks, my lord. They
Why
are,
2 or 3 weeks is required?
my lord, my lord, reported, my lord, if my lord look into his prayer, my his petition, my lord. I think by as he is saying by the report, my lord, by the committee is favoring him, my lord. I think then his grievance in the writ petition, my lord, has been taken care of, my lord.
Therefore,
How
the
can
impunity order has to be set aside.
he can pray beyond his this writ petition, my lord? This report, my lord, yet to be acted upon by the concerned authority, my lord. Report, my lord. Now that liberty, my lord, at least, my lord, the respondent, I believe, humbly believe, has, my lord. Now, whether acted within 2 or 3 days, my lord, that some administrative reason take some time, my lord. Now, his prayer, my lord, in the present only was about rejection of his.
Committee was constituted by you.
You, my lord.
And the committee has submitted its report.
Report, my lord.
Why so much time is required?
My lord,
They are thinking and rethinking on that report. I apprehend tomorrow something will come against us again. So Lordship will protect us.
even if my even if his my lord submission, my lord, later on can't betray, my lord, then his remedy, my lord, to again, my lord. I'm not saying that I will not go by the report, my lord. The situation today is, my lord, the competent authority, my lord, yet to take call on the report, my lord. Now, in such situation, whether this writ petition, my lord, survive on my that is, my lord. Now,
Moment your Lordship set
that
aside the
submission,
impugn
my lord,
order, then we can close this matter. I just want the citation of the impugn order. Because the report now says it is not abnormally low. Therefore, the evaluation of the technical committee was perverse, was unreasonable, without any reasons. In fact, it is without any reasons. If your Lordship will see the impugn order, it simply says we are not satisfied with your grounds, because they asked us to justify as to how you will be able to work on those rates. So we gave all the vendor market list and all those price item list and everything to them based on the justification reply. Then they impugn order, they don't give any reasoned order. They simply say the technical evaluation committee is not satisfied with your reply. It is therefore found to be abnormally low and therefore it is rejected. So we challenged it on that ground.
That's why,
They
my lord,
themselves said
looking
we are
into all that
revisiting.
aspect, my lord,
They
the
issued
committee
a
was formed, my
memorandum for a committee that is already on record.
not only on
Now the committee's report is there. Now they are on the wrong foot. The committee is saying, yes, this is 17% in fact workable. It is workable because it's 70% higher than the market rates. Forget about abnormally being low. This committee, it's a detailed report, Lordship will find
maybe,
there.
my lord,
Now they are
this
delaying.
committee, my lord, I
And this delay
humbly
is
believe,
very
my lord,
dangerous,
will
Lordship,
not
because this delay will give them
generate any
time.
right to him, my lord.
This delay is going to give them
Until and
time to
unless,
do
my
your
lord,
mischief.
the competent authority, my lord, acted upon this committee, my lord. This committee report will not generate any right to him, my lord. His other, my lord, different from this committee report, my lord. We barely acted upon his complaint and the complaint of the other petitioner, my lord. That's why
Lordship
committee was formed, my lord.
Lordship
Now,
will see
committee
those
has
two annexures.
submitted a report, my lord.
The document X, there are 2 document X, in fact, those documents, Lordship. It is a part of the records, Lordship. On 29th of May 2024 was the memorandum.
When the committee has submitted its report?
Lordship, annexer X, I think October, Lordship. I think it is top of the. You've seen the record. Where is it?
Top. That I place on record, my lord, already, my lord. In the record, that is.
There are 2 documents, document X. One is that notification or that memorandum for constitution of the committee. And second is the report. I think it's a month of October, Lordship will find. It's marked as document X, I think. Has you got that? And therein, I think at internal page number 10, because I have seen the records, internal page number 10, the package is Rupa package, serial number 1, Lordship will see. All detailed deliberations took place. Everything is on record. They have gone to the market, verified everything. And their conclusion, Lordship will find that internal page number 10 of that report regarding Rupa package. And serial number 1, I think, in that list. Internal page 10, Lordship, of the report.
I fail to understand, my lord. If report, my lord, is in his favor, my lord, how he can pray some make prayer before this honorable mere apprehension, my lord. If the committee report is in favor, my lord, his grievance, my lord, in the writ petition, my lord, has been taken care of, my lord. Now the competent authority, my lord, yet to act upon that, my lord.
Lordship will first
Until
see-
and that it
Lordship will
acted
first
upon
see that page.
no right,
will
my
see the
lord,
page
negative
10.
or positive, my lord, generated in his favor, my lord.
There is
So
a
mere
impugn
on
order
apprehension,
against
my
me.
lord, how he can make a prayer for
Yes,
passing
there is a impugn order
petition
against
by
me.
court, my lord.
Page internal, Lordship got the internal page number 10. Internal page number 10, serial number 1, Rupa package. After all those examination, they have found that the rate quoted by me is 17% above the market rates. So it is perfectly workable rate that I had given. And I was found to be a
16.30.
Lordship. I don't have the report with me because it was not shared with me. I think, but I've seen it. Internal page 10,
Rupa package.
Rupa package, Lordship. Lordship will read that kind. It says that. Yes, Lordship.
We do 1 week time, next Monday you come with the report.
Well,
The report is there only.
I humbly pray for 2 weeks, my lord. 2 week by 2 week,
No, not 2 weeks. Next Monday.
2 week, my lord.
No,
I am informed, my lord, the concerned authority, my lord. Maybe out of station, my lord. That's why, my lord. 2 week, my lord.
No.
No. When?
Unless, my lord, I humbly believe, my lord, what right he now to be executed by this honorable court, my lord. If he's saying his report, my lord, is
We have seen the pair in the rate petition. Have
Pardon?
you gone through the pair rate petition?
prayer, my lord, prayer simply is to page number 23, my lord. His prayer, my lord, set aside the order dated whereby the bid of petition were rejected, my lord.
Have they withdrawn this order? They haven't withdrawn this order till now.
No, that way, my lord.
Lordship, my
That way, my
Just
lord.
let me just
He's
finish.
giving
My case is, just me please. My simple case is, there is an administrative order against me by the department, thereby setting aside or thereby cancelling my bid. That is this impugn order. Now, I say that this impugn order is bad in law because it was without any justification, it was perverse. I come before this honorable court balance. Now, they themselves, I was grateful to them. They themselves therefore said, we are going for an independent committee. Your lordship could have also asked for an independent committee. Lordship has this power, plenary powers. But then they said, we are going for a review by a new committee. It will be an independent committee. Now the committee has given a report. It's a fact-finding report. Now the report is before your lordships. So therefore, lordships can therefore very well derive the satisfaction that this impugn order is bad in law. So my prayer for your lordship is to therefore set aside this order now. It is their report. My learned friend is saying that the report is in my favor. Then why am I worried? I am worried because the impugn order of rejecting is still on record. It has not been interfered with, neither it has been withdrawn by them. So that is my apprehension.
that time, my lord, the competent yet to act
Let
upon
them
the
say that
report
they are
favoring him, my lord. Yet to
Mr.
acted,
Pandey, otherwise we will set it aside.
my lord.
That is my prayer.
I am giving you 1 week time. You come with the report. Otherwise,
I humbly pray for 2 weeks, my lord.
no 2 weeks. Next month.
In my lord,
Next Monday.
I humbly believe, my lord, in absence of the competent authority, my lord, the order, my lord. Ultimately, this report, my lord.
Lordship will kindly observe that they will pass an order for awarding the contract based on this report.
No, my
Because why no? That means
cannot
they're going to change the report now.
Well,
Why?
that
Why this apprehension to act on the report? Their own committee, their
That's
own
why I
report.
submitted my this
Something
report,
is
my lord.
brewing. Something is brewing in the
This is-
background. That
this-
tomorrow is going against me.
This report is a part of procedure, my lord. This will not give any right to him, my lord.
Is it?
Whether this report can be accepted or rejected by the competent authority, my lord. This report only would not parameter to accept his bid, my lord.
We will not observe anything in the order sheet. Just we are giving time to you. 1 week time. You do whatever you like and apprise this court on next Monday.
2
Then
months
the-
they are.
will do
2 months they have taken time this way only. I really apprehend something is going to happen. Lots of
no,
background.
1 week time only.
Let it be on
Lord
Wednesday.
Mr.
On
A.
Wednesday.
Sharma, Lord, I consider for the petition and Mr. L. Parme Learned Standing Council for the respondent number. All the respondents?
All the respondents, I think,
All the respondents. List this matter on next
on Wednesday also.
Wednesday.
Why 11? On 11 I can come. On yes, on Wednesday.
For further deliberation.
Obligation.
Oblige, your Lordship.
You know, I'm advancing my arguments. In WPC 242 of the
242.
90. Because you know, replacement petition, which is earlier than point of time of 2020, we had assailed the legality of the order. As a counter class, they had earlier filed a writ petition, which was subsequently withdrawn, and then they filed another writ petition, that is 230 of 2024, seeking enforcement of the same. So therefore, you know, these two petitions were joined together, 18 and 19. So, you know, since NFPC is the petitioner in WPC 240 of 2020 challenging the award. So therefore, you know, on that I'm placing my arguments. This is, my lord, debate part 2. Because my lord is familiar, my lord, with the main project in debate. There was an award of 1,600 crores, something, etc. Now, you know, there were lots of families that were displaced, that would be displaced once the project takes shape and there is submergence and the reservoir gets filled up. So, for the resettlement of 41 families, a land was acquired at Bhishmak Nagar.
At?
Bhishmak Nagar. Bhishmak. Bhishmak Nagar in Lower Debang Valley. There were not 142 hectares was acquired for resettlement of those who are likely to be displaced from the main project once that comes. Now, in this very particular acquisition of Bhishmak Nagar, this acquisition was under Section 10 of June Land Regulation. They applied the principle of compensation assessment under 2013 Act. That's fair. We will not challenge it now. But while assessing the compensation under 2013 Act, they also took into consideration RNR scheme of 2008 and applied the principle of compensation assessment there and now, thereby resulting in duplicity of compensation. So, my lord, it is the other part on which my principal focus will be as to whether, while applying the principle of compensation assessment under the 2013 Act, can you fall back upon the RNR policy of 2008 and apply the principle of compensation assessment there or there? Whether this can be done is the core of the issue. Another thing I clarify. So far as June Land Regulation case is concerned, my lord had some occasion to deal with this issue in one of the matters. The matter was subsequently taken to division bench, that's a different story. But you know, in the Mihin Tali case, that is the judgment of division bench of this very honorable court. The honorable court affirmed that yes, there is nothing wrong in application of 2013 Act in assessing the compensation when the land is required under Section 10 of the June Land Regulation. That part is all right. But in the Mihin Tali case, my lord, it is important to note there was no application of RNR policy 2008. Not only in the Mihin Tali case, RNR policy was not taken into consideration. Subsequently, my lord, in another Debang case, and I will show the report to the lordship, that is also annexed
and part of the record. In Injono also, my lord, a similar land was acquired under section 10 of the June edition. Compensation was assessed under 2013 Act for settlement of the people displaced from the Diwan multi-purpose project. And there also belonged in the Injono case, they did not apply the principle of 2002 assessment, 2008 policy. So, my lord, there are precedents where the state of Arunachal Pradesh did not apply the principle of compensation assessment under the 2008 policy and applied only 2013 Act principles. But in this case, we are not deviating from the past precedent. They also applied the principle of compensation assessment under 2008 policy. So that is not an issue for my lord's consideration as to whether this is legal or illegal. Apart from this core issue, there would be other technical aspects in this case, namely, I would be referring to the relevant schedule of the 2019 Act to show that while making the calculation, in calculation, there is a sequence that has to be followed. That market value multiplied by this, multiplied by this, multiplied by this. So that sequence is there. That sequence also was not followed. There was a departure from the sequence. As a result, the figure which came out was incorrect. So these are the two principal aspects of which I will be addressing. Now, straight away, I turn to my petition 242. I'll just give the sequence of events. While referring to the election, I would not go into the details of facts. Only the relevant elections I will raise before the law. My lord, begin with election P1, page 41. Page 41. 39 it is happens. Page 39.
Yes.
Address to Deputy Commissioner with reference to the subject cited above, please find enclosed herewith and receipt provisions for rehabilitation and resettlement at Bishop Nagar, election such and such of 2013 Act in respect of the multi-purpose project. This is the requirement. Lordship would see page 41, go on the right hand side. It is for the settlement of these families. Page 41. 41 families multiplied by 2 hectares from cultivated to unirrigated land per family as per state another policy. That is it. So 41 families were to be resettled. Which would have been displaced once the project comes up. And that is not actually under chapter 8 of the another policy. These families, they are entitled to relief and rehabilitation. So in terms of that arena, they have to be resettled. So for their purpose, the requirement. Now comes the acquisition. Acquisition will not have paid 42. Notification dated 30th August 2018. Whereas it is issued under section 10 of Paripara Freedom Sabya Frontier Act 2 Regulation 1947. Whereas the power to acquire land is vested with the government of Arunachal Pradesh, and it is the competence of the government to notify any land within the state of Arunachal Pradesh for public purpose under section 10 of Zone Land Regulation. Whereas the Deputy Commissioner cum Administrator RNR DMP in his capacity as Administrator RNR dated 20th March 2018 has requested Deputy Commissioner cum District Collector to acquire land in Vardhaman Valley for rehabilitation and resettlement of flood affected families in the DMP, such as such. So now, my lord will find the schedule and the specification of land. District Lower Daman Valley, Circle, Koronu, Bishop Nagar. Area 142.61 hectare. Total, this is the land. Under regulation 10, the big land regulation. This is it. The next is I'll come to annexure P4 at page 45. This is the award. Page 45. Government approval for draft award dated 15th December 2018, Secretary Land Management. With reference to your letter number such and such on the subject cited above, I am directed to convey the government approval for draft allot amounting to rupees 42 crore 6,62,641 toward payment of compensation of land in respect of acquisition of land illegal measuring 142.6 hectare, including 7.5 hectare approach road such as such and such. So this is a law. Now you can see the breakup at page 46. Description of land, column 4, horticulture, waterable, cultivable, waterable, such and such. Or here, my lord will notice column 6, amount allowed for trees around calculated. Then at column 12, my lord will notice damages additional 25% of NPV, net present value. This they have taken 25% from the RNR policy 2008. The other breakup I will show you on the next page. There they have given the details. Category and above.
You are referring to serial number 8.
Serial
Yes.
number
8 additional compensation.
12%, but I am on serial number 12. My lord will see 25%.
Damages.
Net present value, NPV. 25%, serial number 12. That comes from RNR policy 2008. RNR, the 2013 Act will not provide for NPV. The other details my lord will get, page 47. The details.
Yes.
One, land to be acquired, rate of land. So far as the rate of land is concerned, this knows very well. Here there would be no sale deed. Land can't be sold. Practically, so sale deed is not available. So land rates as notified for Demand Valley as per Government of Arunachal Pradesh budget notification dated 4th January 2012. So they have taken the rate fixed by the government as per notification. Rate of property again as per government notification, property and land factor. Now, as per 2013 Act, they have taken factor also into consideration. Again, this is also we are questioning because our cases factor is applied. You bring in the factor of 40 as provided in 2013 Act when there is a sale, when the market value is available. When there is no market value, when it is a manufactured rate by the government, the factor doesn't come in. That's one part. Then comes the user right. User right 1,56,000 as per state another policy. Again, this we are questioning. This could not have been taken into consideration. User right. Then after calculating user right, then they came for solidity 100%. Then plus 12% interest. Lastly, also to see 25% of NPV. Again, as per the RNR policy. So, my lord, there are three factors. Number one, the factor could not have been taken into consideration. Number two, user right, 1,26,000 as per state RNR policy. Again, this is under RNR, so could not have been. Then 25% of NPV, again, it is in terms of RNR 2008. 2030 doesn't provide for all this. So that is how, my lord, they calculated. Lordship will find from the chart, page 40. There is a type copy also, my lord. The next page also may see that will be more clear. The factor my lord will find at column Roman 6. Factor is 1.40 there. Our contention would be that factor could not have been taken into consideration because it is the corporate manufacturer. No factor. Then column 9. Community property. User right 1,56,000 under RNR policy 2008. They have calculated in terms of individuals and respective figures they have given. Then my lord will see 25% of the NPV. At column 18. So far as the sequence is concerned, I will also give the sequence. Rate, factor, final rate they decide, total land value they calculate, multiplied by, then they bring in 1,56,000. After adding it, they go for different factors, then 12% interest, total compensation, thereafter solidity, then 25% of the NPV. Sequence I will give you. I will show with my chart as to what ought to have been the right sequence in terms of the schedule. Now, so far as the errors are concerned in the award, broadly, I am just noting it out. Compensation under the head, loss of rights and privileges of private
You
people.
are referring to page number?
No, I am not referring to any page number, I am just taking broad subject
Okay,
in terms of the errors.
okay.
The first is below compensation under the head, loss of rights and privileges of private people to collect and use forest produce from USF at the rate of rupees 1,56,000 per hectare for USF area under chapter 9 of the RLR policy 2008 could not have been taken into consideration while assessing the compensation. 2. Additional compensation to community against extinction of their traditional rights over USF land use on diversion of USF at the rate of 25% of NPV could not have been calculated. Thirdly, calculation of the amount at the rate of 12% per annum on the compensation which was arrived at prior to the imposition of solitium. Now, interest should come after the solitium, not before the solitium. So they have calculated 12% interest per annum prior to solitium. Then they bring in the solitium and make it down. Calculation becomes different, if the right sequence is followed. Whereas as per the 2013 Act, the amount of 12% interest is calculated after the imposition of solitium under the 2013. Here they have done before. Then we have multiplication of the factor of 1.40 over the rate of land for deriving the total land value. To derive total land value, they applied the factor of 1.40. They multiplied it. Since the rate of land was determined by the government by fixing the rate of land for the whole district by way of notification, they could not have brought in this factor of 1.40. That's my case, because Lordship will see the scheme of 2013 Act is very clear from the scheme that it is, since in market value with sale deed and all, there is always that fluctuation. So therefore, they arrive at a particular figure. So this factor is applied 1.40 as a rule of thumb. You can't, it's manufactured rate. So now, the further sequence, anyway, I'll come to annexure 6, page 51. This is the broad parameter, a lot of business will level.
It's number 56.
Page 51, annexure P6. When the award came, the general manager NSPC objected to the award. Page 51. This I read. Lordship from second paragraph. It is to inform that the award issued while letter referred above was examined at the project and it is observed that the compensation as per the Andhra Pradesh State RLR Policy 2008, clause number 9, 3 for extinction of traditional rights over the use of USF land at the rate of 25% NPV has been enumerated. In this regard, it is submitted that NPV, net present value, is to be paid for the forest land of, this is 4,577.84 hectare. This is not the main project. So they are referring to that. That NPV is to be paid for that forest land, submergence area of 349 hectares, such and such, which indicates that the land for RNR at Bishop Nagar doesn't come under the purview of NPV. Moreover, DFO HU has also informed that the area bounded from the said RNR site is not a part of notified forest. I deal with all this. This was the basic objection. You could not have brought in the RNR in 2008. Well, making calculation under 2013 Act. Then the general manager wrote a detailed letter to the Deputy Commissioner, dated 12/6/2019, and Connection 7, page 52. It has some relevance. I will read three paragraphs of this. The first, in connection with the above, the matter has been and further to letter number such as dated 8/3/2019, it may be noted that the aforementioned award is integrally connected to the fate of Dibang multi-purpose project, for which the Government of India, Ministry of Environment and Forest, on proposal of the Government of Arunachal Pradesh, approved the diversion of 4577.84 hectare of unclassed state forest land spread across Dibang Valley and Lower Dibang Valley district under the provision of the Forest Conservation Act 1980. Now, my lord, I just pausing here, I clarify that my lord may recall, because also had an occasion to deal with the Dibang case on quite a few occasions. In Dibang case, my lord, it was the USF land for the main project. For which, my lord, there was in principle approval of the Government of India under Section 2 of the Forest Conservation Act 1980, diverting 4,577.34 hectare of USF land, main project. So he referred to that. He said that it was that as a result of that, the displacement of 107 families settled in the village Avali, Alihi, Aprali, Kano, New Anaya of Dibang Valley district in terms of Arunachal Pradesh Rehabilitation and Resettlement Policy 2008. These 41 project affected families out of 107 PA are to be resettled in Bishpak Nagar, for which NHPC has to provide. This was not part of the scheme of rehabilitation and resettlement, that 41 of these families will be settled at Bishpak Nagar on the land which will be acquired by NHPC with the assistance of the state of Arunachal Pradesh. So it makes it clear. Then comes para 6 at page 53. Next page. That has, under the existing circumstances, the Dibang multi-purpose project is not making any progress, because the main project also lots of litigation, and in practical terms there is no displacement of 41 families settled in the village Avali such and such of Dibang Valley district. Therefore, there is also no question of their resettlement on the land at village Bishpak Nagar of Lower Dibang Valley district, which was acquired by the Government of Arunachal Pradesh for the resettlement, for which an award of rupees 42 crore 6,62,041 was made. Under paragraph 7.2.4 of Arunachal Pradesh Arunachal Policy 2008, if land compulsorily acquired for a project or part thereof remains for the project for a period of 5 years from the date of taking over the position by the requiring body, the same shall revert to the position and ownership of the state government without payment of any compensation or remuneration to the requiring body. So, my lord, he referred to it as a measure of 100%. He said, look here, if we pay the compensation and all this and this happens, then what? The land also will go, the money also will go. So, the next para he writes, para A, that since NHPC has decided to challenge the legality of the award of rupees 42 crore such and such before an appropriate forum, it has been decided not to take possession of the acquired land. Hence, the beneficiaries of the award may kindly be informed that they should not stop cultivating crops and other agricultural, horticultural items in the acquired land at Bishpak Nagar. Even if the project starts, it will take minimum 7 to 8 years to complete. So, NHPC said, look, we are not taking possession. We are challenging this 42 crore compensation award, and you please continue with the cultivation, farming, etc. We will not take possession of this land. Let the issue be settled. So this is the communication. So, till date we have not taken the position. Now, next is annexure P7. P7 I have already read. I'll now turn to annexure P8, page 54. Now, what happened was, since the Dibang Valley main project for settlement of inspectional acquisition of land at Bishpak Nagar, there were total 4 awards: Dibang Valley, Lower Dibang Valley, and Bishpak Nagar and at Enjoma. So, since there were lots of illegalities, there were errors, and amount was astronomical. So the government of Arunachal Pradesh had called for a meeting. So there was a discussion, all the stakeholders were involved in the discussion, and this file will find at page 55. Page 55, annexure B. Last para at page 55. Deputy Commissioner of Lower Dibang and Dibang Valley District expressed their view that there is a need of reviewing the awards in right earnest in the interest of district. So for review, the land management has also expressed that that the rates suggested by DCs are being followed through, it will vary from district to district. Secretary and land management has also expressed his acceptance for review of the orders already passed and briefed as Honorable Deputy Minister on the nuances of the land acquisition process, suggested also suggested to form a committee for speedy resolution of state. So therefore, my lord, the committee was constituted, the high level committee, to look into, to review everything. After the review, my lord, they passed the order on 6th August 2019, page 57. The order was passed. The third paragraph of message. From the top, the third paragraph, and whereas it has been observed by the government that different rates and methodologies has been adopted for acquisition of land, especially in Dibang Valley district, a different factor of multiplication due to distance of the area of acquisition from nearest town by the district authorities of Dibang Valley has been adopted, and even for assessment of compensation of trees by the Forest Department of Dibang Valley, a methodology has been adopted which is absolutely irrational. It has also been observed that a huge compensation has been assessed for standing crop plantation and other assets by the officials of Dibang Valley. And whereas for the same and one project, payment of compensation cannot be made by following different guidelines. As such, the issue, if challenged, shall not withstand the scrutiny of the court. Now, therefore, after having considered the entire facts and circumstances of the case, the competent authority hereby orders as follows. Rate modified by notification of such and such 4th January 2012 for Lower Dibang Valley be taken for the purpose of assessment of compensation of land for the said project having reservoir area, and that is the principal project. The value of land shall also be required to be compensated even for unclassified state forest, being the area used by the scheduled tribes such and such. As there was no separate notification for the rates of property, notification taken such and such as adopted by DC, Lower Dibang Valley shall be adopted. We will not inspect all the 4 awards, because in the principal award, the USF land was involved. In some other award, June land was involved. So considering everything, they gave the guidelines. Compensation for the loss of rights and privileges of tribal people to collect and use forest produce from USF area at the rate of 1,56,000 per hectare, and compensation against the extinction of additional rights over USF land at the rate of 25% of NPV as per state original policy shall be applied only in respect of unused USF land and not for the land being used for the purpose of residential, horticulture and the agricultural land, etc. So all the things, but anyway, it is applicable only in respect of the USF. I will demonstrate here the June land was there. So we have guidelines and all were there. I'll skip this. Thereafter, the order was issued 28th December 2019, page 59. So the guidelines were reiterated. Dated December 6th, 2019 was issued as guidance for the purpose of assessment of award by DC Dibang Valley and DC Lower Dibang Valley for acquisition of land for the Dibang project. The guidelines, multiplication factor, etc., etc. The relevant portions, some of it could be brought in see page 60.
Yes.
B. At the top, the registered sale deeds or agreements to sell is mentioned in clause A of subsection 1 for similar land are not available for the immediately preceding 3 years. The market value has not been specified under the Indian Such. 5. It is therefore from the above that as per LARR Act 2013, subsection 2 of section 26, the multiplication factor is specified in first schedule is to be loaded on the market value of land calculated in accordance with subsection 1 of section 26. In the state of Arunachal Pradesh, sale, purchase or transfer of land is based but generally no sale deed is registered. Land normally cannot be sold outside the clan, and thus the market value under subsection 1 of section 26 are not applicable. Subsection 3A, 3B is applicable. The market value of land is being fixed as per subsection 3 of section 26 from time to time for different area or districts by the government of Arunachal Pradesh, and also the rate for urban area and rural area are different, and the land in rural areas does not have any locational disadvantage. Therefore, the multiplication factor does not apply on the value as calculated or determined under subsection 3 of section 26. I am emphasizing upon this because they consider, and this is the reason for which we are objecting to application of multiplication factor of 1.40. We say, look, no sale deed, nothing is available. It's a government manufactured rate. Therefore, it is clarified that the order number such and such dated 5th July 2016 only the rate for particular area is fixed in accordance with provision of section 26(1) of the LARR Act 2013. The government of Arunachal Pradesh is pleased to issue following clarifications and direction in respect of various concerns raised by the representatives and officials. A, in view of explicit provisions of LARR Act and above facts, in respect of Arunachal Pradesh, it is hereby observed that there will not be any multiplication factors to assess the compensation, i.e., multiplication factor will be for both the districts, one for both the districts. The sonatium shall not be payable on the interest amount as well as on the amount given under the state RNR policy. We are not getting so technical, we are even agreeable with the sonatia, but our objections will be different. The rates published by state PWD in 2018 shall be used for the purpose of assessment of compensation. D, the correct entry for uncultivated land be used by the district office. The award prepared earlier by DC Lower Kumang Valley and DC Kumang Valley stands rescinded, and both the DCs Lower Kumang Valley and Kumang Valley are requested to prepare fresh award based on parameters as above in para 7 as communicated such and such. So government approval. So this was done. There was a hue and cry, public pressure, and as a result, page 62, because the writ petition was also filed, and in the writ petition, it was argued at the motion stage that look here, in this very case, there is an award, the award cannot be like rescinded. So there is no question of rescinding the award. The award making authority is not functus officio. So be that as it may, there was some mistake. And immediately thereafter, the order was recalled. Page 62, all these orders were recalled. Connection plan. No, my lord, this is the sum and substance, this is the sequence of events. So thereafter, my lord, we filed this present petition. We filed this petition. Initially, there was a great degree of confusion. We were also not sure about the status of the Jhum land, what exactly it is. But my lord, substantive clarity has come when the affidavits were exchanged, and even the private respondents in the state of Arunachal Pradesh, they made their stand very clear. So now, my lord, I will take your lordship to specific elements made in the affidavit in opposition of the respective parties. What do they say about the land? I'm sorry. Actually, not on 26th of November. On this 26th of November, the state filed additional affidavit, bringing on record a particular document about which we feel the document doesn't apply to the case. So, what we did, we filed counter to that very additional affidavit this morning. So, this has also been brought on the record, this counter to their additional affidavit. Now, I am taking the lordship to affidavit in the position of respondent 1, the state. This is relevant because it makes the stand of the state very clear on the nature of it. Affidavit in a position of respondent 1. I will read you paragraph 19 of the affidavit. In total, page 9. internal page 9. That is, regard to the statement made in paragraph 45 of the petition, the upper deponent,
एक minute.
I'm sorry.
Yes, you are reading the affidavit in opposition dated 24th May.
Yes, yes, 24th May 2024.
Paragraph number.
Paragraph number 19, 19. Internal page 9.
Yes.
That is regard to the statement made in paragraph 45 of the petition, the upper deponent vehemently denies that Jhum land in Arunachal Pradesh enjoys the status of forest land as stated by NSPC Limited. That the upper deponent begs to state that a Jhum land is defined in section 2B of the Jhum land regulation 1947, which read as follows. A Jhum land means and include all lands which any member or members of a village or community have customary rights to cultivate by means of shifting cultivation or to utilize by clearing jungle or raising livestock, but doesn't include any land which has been or a process of being terraced for the purpose of permanent or semi-permanent cultivation, whether by means of irrigation or not, unquote. And the term forest must be understood according to its dictionary meaning, a large area covered chiefly with trees and undergrowth. According to these definitions, a Jhum land cannot be treated as forest land, although an individual or village or a community enjoys a traditional and customary rights over Jhum land as well as over USM and forest land in Arunachal Pradesh. The humble deponent reiterates the statements made in the following paragraphs of the affidavit in opposition and begs to state that USM is a general concept and traditionally the land belongs to the tribe indigenous of the state who have been living in these land and cultivating these land memorial, and their rights and privileges have been duly recognized by the state government. It is these rights and privileges that tribal people exert over these lands, irrespective of whether it is the Jhum land or a USF stroke forest land. In the instant case, the land of the private respondents, landowners, does not fall under any reserve forest of the Bengal Forest Division. So, my lord, they have made it very clear it doesn't fall in under any reserve forest, not under any notified reserve forest. They also annex the LOC of 15/10/2018, and it is a land of the private owner, and it is not a forest. Then comes paragraph 29. Paragraph 29. Internal page 16. That as regard to the statement made in paragraph 59 of the writ petition, the humble deponent reiterates and submits that Jhum land doesn't fall under the category of forest land, neither it can be treated as forest land. The Jhum land is a land within the meaning of section 3 and is owned by a private individual or community. As the case may be, here it is individual, not community, that also I am going to show, which confers upon it the status of a private land. Which confers upon it the status of a private land. This is what I am emphasizing upon, and may not be agreeable with this proposition. Yes, it is a private land. Hence, the principle of Act of 2013 is applicable in this case. Again, my lord, we accept it. Paragraph 29. Then comes, my lord, paragraph 30. The same thing, my lord, is repeated in different language. I'll skip it. The same thing has been said over here. Paragraph 23, thereafter the 19 also. The same principle, the same thing repeated in this paragraph. Now, my lord, I come to affidavit in opposition of the private parties. Affidavit in opposition of private parties, respondent 3 to respondent 11. The first paragraph, respondent 3 to respondent 11. I'm sorry because in my case, the continuity of the
Yes, okay, I got it.
Respondent 3 to 11. Whether my lord has got it.
Got it.
Paragraph 7. Paragraph 7, internal page 14, 14.
Yes.
That with regard to the statements made in paragraph number 2.3 and 2.4 of the writ petition, your upper deponents vehemently denies the same and begs to state that the proposal for establishment of the Dibang multi-purpose project at Goi under Lower Dibang Valley was opposed by the project affected landowner at initial stage for the establishment of proposed DMP. However, after threadbare and relentless discussion, finally, the project affected land owners consented for construction of DMP by the NHPC Limited on the assurance of just and adequate compensation under the provisions of RFCT and LARR Act 2013. And rehabilitation and resettlement of 41 families facing displacement due to acquisition of 1,732.432 hectares of private and community land. The state respondent, from here onward it becomes relevant law, the respondents identify private land of the humble deponents. So they say the state respondent identified their private land measuring 142.61 hectare at Rishpat Nagar under Kororu Circle in Lower Dibang Valley district of Madhya Pradesh. For the purpose of acquisition, Deputy Commissioner sought clarification from DFO whether the identified land falls under reserve forest. The DFO by communication letter such and such dated 5/11/2018 has forwarded its verification report that the identified land does not fall under any notified forest. Therefore, acquiring the private land of a humble deponent, the Deputy Commissioner Dibang Valley Anuni wrote letter dated 20th March 2018 to the Deputy Commissioner Roing, Lower Dibang Valley District for taking adequate measure in terms of rehabilitation and resettlement, and as per section such and such of RFCT and LARR Act of 2013 for acquisition of land measuring 142.61 hectare, which is private land of your humble deponents for rehabilitation and resettlement of project affected families. That the private land of your humble deponent has been identified by state respondent as because there is no proof at Dibang Valley district for rehabilitation and resettlement of project affected families. Such and such. Therefore, the Deputy Commissioner Lower Dibang Valley was directed to acquire the private land of the humble deponent falling under his jurisdiction. So this is relevant law. They clearly say it is their own private land. Then paragraph 10. Paragraph 10 about straight away your lordship can in fact 7th line from the bottom. 7th line from the bottom. Further the private line. 7th line. 7th line from the bottom. Further the private line. That is my lord is bottom. It is the page 40. 7th line from the bottom. The private land. The private land of the humble deponent are located in Asbai, Itiango village. They are giving the history in fact, not the earlier the Rishpat Nagar was Itiango. In Asbai, Itiango village, and people of Itiango was later relocated at Ihengo, another part of Rohit area. However, the people of Itiango village never gave up their activity over their land at Itiango village. Instead, developed. So, they no longer live there, but according to them, their cultivation was there. They were doing the cultivation permanently. Over their land at Itiango village, instead developed agriculture, field, WRC field, horticulture field, etc., which is main source of livelihood. As such, your humble deponents' land are plain area, not a hilly terrain and easily accessible. It's a plain area according to them. Then we note again. 9th line from the bottom, internal page 41, the same page. 9th line from the bottom, internal page 41, the same page. Further, the acquired lands.
Internal page
41. The same page which I was reading the last time.
Yes.
9th line from the bottom.
Hmm.
Further, the acquired lands are purely private lands. That's my lord has gone.
Got it.
Yes. Further, the acquired lands are purely private lands owned by the project affected families since time immemorial. The concept of USF is not in existence in the whole state as of date. As such, it is evident from the note dated 10/8/2014 under the heading status of unclassed state forest area issued by the Chief Conservator of Forest of Andhra Pradesh, who is the authority responsible for notifying USF areas himself, has stated that there is no notification constituting USF in the state of Andhra Pradesh. Thus, the NHPC Limited is not the appropriate authority to identify USF or forest land out of its own imagination and vague concept. And therefore, the terming the land of project affected families as USF land by NHPC Limited is wrong and misleading. Furthermore, the land to be acquired, stroke diverted, is a private land, and hence proceedings under June Land Regulation 1947 Act and RFCB LARR Act 2013 stand valid. In fact, my lord, the writ petition which was subsequently withdrawn, and in fact, if I recall correctly, in the present writ petition, they have stated, in fact, they are surprised as to why straight away the 2013 Act provision was not taken into consideration for acquisition proceeding. Instead of section 10, the land would have been easily acquired under 2013 Act. We agree with them if that be the case. But then why do you in that case bring in another points? Para 11 also, page 23.
Yes.
With regard to statement such and such, the writ petition humble deponent offers no comment taking matter record. However, it is pertinent to mention here that there is no USF land in Andhra Pradesh. As such, it is only a vague concept invented by NHPC to deny just an adequate compensation to affected families. Then we know para 12. 8th line from the bottom. 8th line from the bottom. That your humble deponents, private land, why not is important? Your humble deponents, private land, which is plain land in nature, is located at erstwhile Itiango village, and people of Itiango was later relocated to Itiango, another part of going area. However, the people of Itiango village never give up the same thing, absolute ownership over their Itiango village. Instead, developed agriculture, feed, tobacco, feed, agriculture, such and such. Same thing they repeated. It is not a forest land, plain land, and that. So, my lord, this is not a case of respondents. Now, my lord, it is important also to know that the award in question, impugned award in question, is dated. This January 2018, the approval was on 15 December 2018, so I will take it 15 December 2018. They have approved the award. So, my lord, from 15th December 2018 to till date 2024, because had it been USF law, then the diversion of such a USF land was necessary, and diversion is not possible unless and until there is in principle approval of central government under section 2 of the Forest Act 1980. So till date, no proposal from the state, and consequently also, my lord, there is no in principle approval for diversion of such a, because it was not necessary. Nothing was done till date for all these years. So, my lord, I would presume it is indeed a private land over which there is a permanent cultivation or horticulture of the private estates. In that case, to that extent, my lord, the very contention that the land could very well have been acquired under 2013 Act is valid, but in that case, you only allow principle of compensation assessment under 2013 Act. Why do you deviate from that? Now, my lord, I will turn to the June Land Regulation itself. The June Land Regulation, my lord, is annexed with the petition. It is annexure P14,
Annexer?
P4014. It starts from page 65. My lord will see the definition of homeland at page 67. Definition clause, section 2B. Or regulation 2B, whatever we give a context. At page 67 of the regulation.
67.
Yes, sir. Definition of homeland. What is homeland? Homeland means and includes all lands which any member or members of a village or community have customary right to cultivate by means of shifting cultivation or to utilize by clearing jungle or grazing livestock, provided that such village or community is in a permanent location, but does not include what it does not include. One, any land which has been or is under process of being terraced for the purpose of permanent or semi-permanent cultivation, whether by means of irrigation or crop. Two, any land attached and pertinent to a dwelling house and used for the purpose of permanent cultivation. Or any land which in the opinion of Deputy Commissioner is subject to permanent cultivation. So, my lord, if we go by what has come on the record, it being a private land under permanent cultivation, one may argue it is not even a homeland. But, my lord, I would not really harp much upon this, because even if it is not a homeland, maybe it was wrongly acquired under section 10 of the homeland regulation. I accept the principle that yes, there was nothing wrong in assessing the compensation under the 2013 Act. So you apply that, but then stick only to that. And follow it correctly, don't change the sequence. That is going to be the basic thrust of my argument. Because they are not prejudiced. Because principle of compensation assessment indeed was applied under 2013. But our grievance lies somewhere because you bring in another policy 2008. That also I will show whether it can be brought. But few more things. Interestingly, the homeland regulation makes a distinction between the customary right of a community and customary right of an individual. The homeland envisages a possibility, regulation envisages a possibility where in a given case, homeland will be owned by a community or owned by an individual. Distinction is made. For argument's sake, if it is said that this homeland is indeed homeland, but then it is owned by an individual, not by a community. The consequences of that will be different. And it is relevant not for the purpose of the present case. So community has been defined. At definition clause 2C, community includes the residents of the village as a whole, the clan, the sub-clan, such and such. So, nothing is left to done. Then, 4.2, a customary right to choose land shall be deemed to be established in favor of an individual cultivator. If he inherited the land in accordance with the local custom, various things. Purpose is to show individual are two different things. What is meant for a community can't be given to an individual. And what is meant for an individual can't be given to a community. This is the purpose. Now, Lord, Regulation 10, my lord is familiar, I need not. Regulation 10, Lordship has a location to interpret it, and that principle is accepted even by the division bench. Reasonable compensation, Lordship held rightly that reasonable compensation doesn't mean that 2020 you consider that. That will be applied. DP also put the same view in the Mirinani case. So there is no deviation. I will just skip that. Now, I will come to another policy. This was, Lord, this policy was applied so far as main project of Dibang is concerned. Whereunder there was a diversion of 4,577 hectares within principal approval of the government of India under section 2 of the Forest Conservation Act. Now, what is the Anandar policy? What is the scope of the Anandar policy? This one will find in the writ petition itself. It is annexure P16. It starts from page 82.
Yes.
The Lord, I admit the fact, my esteemed colleague Mr. Das, would be getting crores. My only endeavor is to ensure how much I can reduce the amount. So in any case, he's getting the crores. Where is the page 83. Para 1.4. Para 1.4 to para 1.11 are in place. How another policy 2008 came into being? The National Rehabilitation and Resettlement Policy 2007, that was national policy law, emphasizes that although the NRPP 2007 provides for the basic minimum requirements, the state governments, public sector undertakings or agencies, and other requiring bodies shall be at liberty to put in place greater benefit levels than those prescribed in the NRRP 2007. So therefore, my lord, under para 1.4 itself, it was clearly provided that the national policy was meant for the whole country, but in specific cases, the state government was given the liberty that in terms of the national policy, they can carve out their own policy for giving better benefits to their people. So therefore, we are under that, this policy came into being. It was published in the Gazette of September 30, 2008. It's a gazetted policy. One of late, the government of India has addressed the long-felt need of recognizing and vesting the forest rights and occupation in forest land, in forest dwelling scheduled tribes and other forest dwellers through enactment of scheduled tribes and other traditional forest dwellers, Recognition of Forest Rights Act 2008, as per section 2A of the Act, quote unquote, community forest resource means customary common forest land. All this is vital, very, very strongly worded without sentence. Community forest resource means customary common forest land within the traditional or customary boundaries of the village or seasonal use of landscape in the case of pastoral communities, including reserve forest, protected forest, and protected areas such as sanctuaries and national parks to which the community had traditional access. However, the customary rights of tribal community for land use, including jhum cultivation, shifting cultivation in USF, as practiced in Arunachal Pradesh, do not find mention in the statute. 1.6. As per the provisions contained in section 4.1 of the Balipara Jhum Land Regulation 1947, a customary right to jhum land shall be deemed to be established in favor of a village or a community when such village or community has enjoyed the right to cultivate or utilize the jhum land for not less than 5 years prior to the making of this regulation. Again, para 1.7, the provisions contained under section 10.1 of the Arunachal Pradesh Land Settlement and Record Act 2000 read with the prevailing customary rights of a tribal community makes it clear that the community enjoys the right not only over trees, jungles, or other natural products growing on USF land, which traditionally belong to them, but also for land use. Then comes para 110. Arunachal Pradesh being a mountainous state, heavily forested and drained by numerous rivers and streams, availability of cultivable land is less. Obviously, land suitable for agriculture is a scarce resource. This coupled with the fact that the economy of the state is largely dependent on agriculture and forest, diversion of any piece of cultivable land for a project is bound to have more adverse effect upon tribal community of Arunachal Pradesh then faced under NRRRPP 2007. Therefore, the project affected families need to be compensated adequately. Para 1.11, thus it has become necessary for the state government to have a policy in place to provide for adequate compensation to the tribal community for the adverse social impact and loss of rights over USF, land use, and other privileges so as to redress their grievances which relates to not recognizing the customary right over USF land use while granting compensation such and such. So basically, my lord, it was an acknowledgement of the community right over the USF. It also acknowledges the possibility that there may be a June land over USF, there may not be a June land over USF. It is not necessary that there is a June land over the USF. And it talks about the community, it doesn't talk about the individual at all. Then my lord, definition clause 3.1 community has been defined. Definition of the community is similar to the definition of the community in the June land regulation. Then para 3.5, the definition of June land is also there, similar to the one given in June land regulation of 1947. Then, my lord, it's very interesting, this chapter 9, because in the present case, my lord, it was this chapter 9 which was considered while bringing in the principle of compensation assessment in the award. Chapter 9. At page 90. It is part of the policy.
Yes.
The compensation against diversion of unclassed state forest, USF and reserve forest. Now, note at the outset, I am making it very clear. Here the land is not a USF, not a reserve forest, it has been made very clear. And it is supported by the fact that till date in all these years, there is no proposal forwarded to the Government of India, nor in principle approval of the Government of India under Section 2 of the Forest Conservation Act for diversion of land. So it is neither USF nor reserve forest, and it is not a reserve forest, the government document says so. The NOC by DFO, etc. So one, payment may be termed as compensation for loss of customary rights of collection of forest produce and traditional land use of US. That is the scope of application. Two, and this is very important, without the Roman two. The Deputy Commissioner, in his capacity as Forest Settlement Officer, assisted by Land Revenue and Settlement Officer, shall work out compensation for the loss of rights and privileges, of tribal people to collect and use forest produce. It is the right of the tribal people to collect and use forest produce from USF at the rate of 1,56,000 per hectare for USF area and 78,000 per hectare for reserve forest. So if there is a USF, tribal people have a right to collect and use forest produce. So it is to compensate that you have this figure of 1,56,000 per hectare, which they have brought in for assessment unit 2013. Apparently, not in Assam, I have not come across any case where they are applying 2013 Act everywhere in Assam. Nowhere to bring in these calculations. Then next, Roman 3. In addition, in case of diversion, not here there is no diversions. In case of diversion of unclassed state forest, the community, the emphasis is on the word community. The community shall also be paid. The community shall also be paid compensation against extinction of their traditional rights over USF land use at the rate of 25% of NPV as determined by Government of India from time to time. This compensation to the community is over and above the NPV paid to Campa. Now, this 25% of NPV also they have calculated. This is to be paid to the community for extinction of traditional right over the USF. Here there is extinction of individual right over their private land for which the compensation is being given to them under 2013 Act. Why do you bring it? So this chapter 9 was followed. This is our. Now for a moment, I'll just Briefly, I will also take my word to Arunachal Pradesh Land Settlement and Records Act 2000. State Act. No, the state act will give it ownership to my copy. I hope here. I hope you know that sound is not disturbing with Dr. Mahan.
No, all right.
Because many cases I'm loud, so.
This is only rules.
We don't have got a separate copy.
Okay, okay. Yes.
So let's see, the definition was
Mm.
2C,
Mm.
common land is defined. Common land means any land used or reserved for the common use of a community or village. The community is defined. Community means residents of a village as a whole and includes a clan, sub-clan, like such. June land is defined as F. Same, they have relied on the definition of June land given in the 47 regulation. That I, landowner. Landowner in relation to any land means a person who acquires rights of ownership in respect of such land by inheritance, purchase, gifts, such and such. Then O, personal cultivation. Even personal cultivation has been defined. O. Personal cultivation with its grammatical variations and cognate expressions means cultivation by a person on his own account. My submission would be not in the present case what we find is the personal cultivation. Over. On his own, on the own account. Then the law. Section 9 and section 10 also may kindly be seen. Section 9.
Yes.
It is under chapter 3, you know, rights over land. Section 9. All lands, public roads, lanes and paths, and bridges, ditches, dikes, and fences, all not beside the same, the bed of river, stream, nala, lake, and tanks, and all canals and water courses, and all standing in flowing water, and rights in or over the same, or pertaining thereto, which are not the property of the person or the community, are hereby declared to be the property of the government. So, what is not belong to an individual or a community belongs to a government, some and substance. Then government's rights to trees, forest, etc. Then one, the right to all trees, jungles, or other natural products growing on land set apart for forest reserves, and all land, all trees, brush, wood, jungle, or other natural product wherever growing, except insofar as the same may be the property of any person or community, rests in government. So what doesn't belong? Some and substances, what doesn't belong to an individual or a community belongs to the government. Non-law. Just turn to oh, oh yes. So, please. Now, my lord, this is how giving the calculation sequence, followed by the state is making them. The sequence is state as follows. Then I will show the sequence ought to have been followed. And the third part is errors in determination of the includer. All the three below are put in black and white. The calculation sequence followed by the state is making them all. One, as of market value of land, as per Government of Arunachal Pradesh Gazette notification dated 4/1/2012, because it was impossible to determine the market value of land as per the mandate of section 26 of the RR50 LARR Act 2013. So they have followed this rate notified in the Gazette notification dated 4/1/2012. Nothing wrong, they can do it. That is the sequence they follow. So first, they assess the market value of land. After assessing the market value of land, what they did? Number two, market value calculated as per above was multiplied by a factor 1.40 and 1.20 in terms of section 46 subsection 2. Read the first schedule to the RFCT LARR Act 2013. They brought in the factor. Factor will not be an object. Then thirdly, what they did? Compensation for the loss of community rights and privileges of tribal people of USM at the rate of 1,56,000 per hectare in terms of chapter 9, para 9.1, subpara 2 of the State Rehabilitation Result Policy 2008. This they calculate. Then fourth, determination of value of assets attached to the land in terms of section 29. On that, they added determination of the value of assets attached to the land in terms of section 29. Then on this, they calculated 12% interest on the market value of land calculated after 1, 2, 3, and 4 above. They calculated 12% interest. Then they brought in the solidity. Imposition of solidity equivalent to 100% of the total compensation, which was derived after adding 1, 2, 3, 4, and 5 above. This was in purported compliance of section 2013. Then seventh, thereafter below, award of 25% of net present value on the total compensation, which was derived after adding 1, 2, 3, 4, 5, and 6 above. This was done in terms of chapter 9, para 913 of the State Rehabilitation and Resettlement Policy 2008. Now, the calculation sequence we have given, which ought to have been followed as per the mandate of 2013 Act. Our sequence. As per the Act. One, Lordship may also see the first schedule. It is very clear of the 2013 Act. The first schedule, page 51, that is the same for page number 26.
Page number?
Page 51,
51.
because we have the same schedule.
Yes.
First schedule, it is under section 30, subsection 2. Manner will find
Yes.
that column 1 market value of land to be determined and provided under section 26. Here this could not be done. No sale deed, nothing is available. So the government notified rate. Then 2, factor by which market values to be multiplied in case of poor areas. But then factor, our case is, why do you bring in the factor when rate is government notified? Then after 4, value of asset attached to land or building to be determined under section 29. Then comes solidity under section 20, subsection 1, 5. Solidity equivalent to 100% of the market value. And in that rural areas, final amount and all. Lastly, my lord will see 8. Interest at the rate of 12%. Other component, if any to be included, other component below in terms of section 20, subsection 3 will be interest 12%. There are series of judgments on that. Interest will be after solidity, not before solidity. Because the other component. So we have given our sequence. Page 2, determination of market value of land as per section 26, such and such. Then 2, market values were calculated as per what above to be multiplied by a factor specified in the first schedule to the Act. In the present case, this was not required because market value of land was artificially determined on the basis of land share fixed by the government through budget notification. Now we are pausing here. I also clarify Though those orders were recorded, I want to remember, I have placed certain orders of the government, they gave the reasons as to why factor should not be brought in the present case. These are government notified cases. So we not have place reliance on that also. They might have recalled their order, but those orders were very much there. Government was cognizant of the difficulties because this was resulting the multiplication of the amount unnecessary. Thirdly, determination of value of asset attached to land is provided under section 29. Then fourth, imposition of solidum equivalent to 100% of total compensation which was derived after adding 1, 2, 3 above as per section 30, subsection 1 of the Act. In the present case, it ought to have been 1 and 3 above. 1, 26, 3, value of assets, 4, solidum, 100%. 2 could not have gone into. So 1, 2, 3 above. Sorry, which was derived from 1, 2, 3 above as per section 21. In the present case, it ought to have been 1 and 3 above only. Then 5, interest at 12% per annum on the market value of land, which is calculated after having 1, 2, 3, 4 above. In the present case, it ought to have been 1, 3, 4 above. This is it. So 1, 3, 4 above. I hope you will get corrections there. If I can, the corrections are here.
Yes.
Yes. Yes. Then what we will see the errors in determination of the income amount. That I have given. 1. Since the market value of land was not determined in terms of section 26 of the 2013 Act and it was based on the permit of Arunachal Pradesh budget notification dated 4/1/12, such artificially manufactured market value could not be multiplied by a factor 1.40 and 1.20 in terms of section 26(2), read with first schedule to the Act. Because the very rationale of multiplying the market value of land by a factor was absent due to application of government budget notification dated 4/1/2012. Pausing here, I would say, this coupled with the reasons given by the government. Government practically acknowledged this part. 2. It was illegal to determine compensation under the head for loss of rights and privileges of tribal people to collect and use forest produce from USF unquote at the rate of 1,00,000 per hectare under para 9(1) of the chapter 9 of the state Arunachal policy 2008. 3. It was illegal to award 25% of NPV on the total compensation in terms of chapter 9 para 9.1 subpara 3 of the state Arunachal policy 2008. 4. Solidum was imposed on the amount which was arrived at after including the interest calculated at the rate of 12% per annum on the principal amount of compensation, whereas under the 2013 Act, the solidum only on the principal amount of compensation before calculation of 12% per annum interest. 5. It was wrong to calculate interest at the rate of 12% per annum on the compensation, which was arrived at prior to imposition of solidum, such and such. Both ways. It has to be taken care of. No. The side of the government, so what I am making it very clear from the very beginning. First of all, I will just cite two precedents. This is the fact first. One is we are talking is familiar with the state of UP versus state of Arunachal Pradesh versus Main Lali. Written 15 of 2022, it is not reported, but I have the copy of the judgment. So, because in this case, the land was acquired under June land regulation of June land regulation. 2013 Act only was applied. RLR policy was not applied. There is no discussion on that. And interestingly, the stand of the state is very, very important. This I will show. I want to see initially paragraph 20 and paragraph 21. I'm sorry if I don't have extra copies, but then paragraph 20 and paragraph 21. My lord, direct only begins with a particular name. It was at that very point of time, as his lordship then was. But then this was the stand of the state. Lordship will see direct only. Such and such, advocate general in charge for the appearance in such a such appeal has raised the contention that as the acquisition proceedings were made under 10 of the regulations of 1947 and the provisions thereof not being challenged, and on the other hand, the petitioner having accepted the same, the provision of the Act of 2013 would be inapplicable for determining the compensation for acquisitions. The other contention of such and such is that neither the regulation of 1947 is repugnant to the Act of 2013, nor the issue of repugnancy has been raised in the writ petitions, and therefore such and such had travelled beyond the pleadings. The further contention is that Section 10 of the regulation of 1947 provides only for a reasonable compensation without providing for any politium and interest. The only purpose is to show the extent of the state was that if it is the Jhum land, if you have acquired the land under regulation 10, don't even fall back upon 2013. They were opposing even the payment of solitium. Then para 21, the same thing. Then comes para 64. Finally, the findings of the court, para 64. What the court held. The Honorable Court held, it is declared that the writ petitioners are entitled to the payment of solitium as well as the interest is provided in the Act of 2013 or any other relevant law of acquisition that may have been enforced when the acquisitions have taken place, and the extent of the authorities that solitium and payment of interest are not required as the acquisition are made under Section 10 of the regulation of 1947 to be unsustained. The court held, pay the solitium. Nothing wrong with that. So the purpose is to show what was the stand of the state. And IMF policy 2008 was simply not brought in. Whereas the acquisition was under regulation of 1947. Then the second is in the affidavit in the petition, which I filed in earlier petition 230 that I have annexed, but here in my affidavit in reply I have annexed the same document. That is it is affidavit in reply against
So you are referring to the affidavit filed today?
no. I'll come to that. I'll come to that. That is relevant. Not now, sorry, my learned friend will not get a chance to he'll have to wait. Well, that's a pleasure. You said one and a half. No, at least I have that company, so at least be in the same place.
Just that I'll have to go back and laugh.
Why not be fine?
Always my friend starts 1.5 hours I think.
The other day itself, I had predicted, if he has asked for 1.5 hours, it will be at least 3 hours.
I'm sure my esteemed colleague would be graceful to acknowledge. I have not repeated any other.
No, that I.
This is here it is annexed affidavit in reply against the affidavit in opposition of respondent 1 in the PPC 242. Here again, I'm sorry, but there is no continuity in which. Anyway, my friend is telling me that when it was filed, that system was not there. So I don't know. Anyway, he knows better.
What is the date of filing that?
22nd July 2024, or 23rd July. July 2024, I think it was there possible. Anyway, this is election R1. It is NSPC case only, the Jhum land was acquired at the Domu village, page 53. In terms of page 53. The affidavit is replying against affidavit in the position of respondent one. And it is also in the affidavit in the position of the city. Reply. 22nd. 22nd. My lord. Here you also. Because and there is petition of the Lord, I find counter affidavit, it is next with that counter affidavit also. I think my lord is okay. So, election.
So this is 25th of September 2024.
No, it is this section. May I? Election are which one is that?
What is the document?
It is in your, it is.
You all are, yeah?
Correct.
28/7.
There are petition two places. This is one. It's affidavit of petition of their petition.
Yes.
It is also affidavit in the file.
Yes, Mr. Tewari, I got it.
Yes. So here, what you can find, that they are charged everything. They have brought in 2013 Act without bringing in RNR policy 2000. This is what you can just see. It is not from page 53. Anyway, I will not place everything. Now you will just see the calculation. Not at page 50, internal page 58. Internal page 58.
Yes.
The type copy at page 58, capital A. Type copy. Well, let's see. Land, rate of property, property land factor. As per government of Arunachal Pradesh.
Page number 58.
Yes, madam, 58A.
There is no 58A.
Type copy, madam. May not be, but type copy. It is type copy of the other copy. Page 58, possibly not because of the type copy. Internal sheet 58, whether my one has got it.
58, I got it.
Yes, so I say at least.
But
It's
no, no.
sorry, very sorry.
Can you show it from
Yes.
this here?
Oh, sorry, no, it is fine. It is, since it is continuation, here it is page 69.
69.
69.
Okay.
The that copy is at page. Yes, that copy at page 75.
Yes.
Land to be acquired, as per notification such as such, rate of land rates as notified by lower Devon Valley as per such and such, rate of property as per present notification, property and land as per report submitted such and such, factor as per government of Arunachal Pradesh notification. So no 1.43 were known. 12% interest, very right, on land value. Here we not. Tax holiday, tax sequence, as per 2013 Act, 100% of total compensation. No other policy to come. It is without an injunction for another set of people, project affected people who are likely to be displaced because of the Bang Valley project. The land was acquired at injunction. And that is how the assessment was. There was litigation for other reasons, but finally matter was resolved. There was a settlement between the parties, and there is a ficus was given to the same time. So, the purpose is to show the inconsistency in the state of the government. In Jomo case, no other house, accidents followed. Mehinlawi case, where the land was acquired for national highway, for highway. In that case also, no other policy in 2008. There also June was acquired for the reservation plan. Here may not be adopted another policy. So inconsistencies were found. Then I come to another aspect. First of all, we will have to deal with the affidavit which the state had filed on 26th November. In this Milord affidavit of 26th November, my lord will see page 86. Continue.
Page number?
86. Here the Lord information is correct because it is filed by them. So I am having it.
Yes.
Here the Lord, 19th May 2015 communication is issued by S.K. Srivastava, scientist. That is that even not to see. Scientist from Ministry of Environment. Lord will find from the subject itself, it is directly connected to the Diwan multi-purpose project 2880 megawatt in Goa Diwan Valley district of Arunachal Pradesh, such and such. For environmental clearance regarding. So clearance was given, everything was done in connection with that. This commission was sent subsequently. Para 2 says, the above referred proposal was appraised by the expert appraisal committee, ESC, for river valley and hydroelectric power projects in a meeting held on such and such, such and such. The comments and observations of expert appraisal committee of this project may be seen in the minutes of the meetings which are available on the website. Then comes para 4. The project is proposed on the Diwan River near Mungli village in North Diwan Valley district of Arunachal Pradesh. The project envisages construction of 178-meter high complete gravity dam across Diwan River, about 1.4 kilometer upstream of confluence of Ashupani River with Diwan River for the generation of 2880 megawatt hydropower. This is a storage scheme project with dual purposes, that is flood moderation and power generation. The total land requirement is about 5349 crore. The figure is wrong, it's 5056 actually. Out of which 4577, this figure is correct. 4577.84 hectare is unclassified state forest, 701.30 hectare is community land without forest cover, and 50 hectare land under wet rice cultivation. Total submergence area is 3564 hectare, out of which 1176 hectare is river bed. The total catchment such and such. Now then it is the 115 families of 5 villages are likely to be displaced, and 744 families of 39 villages are likely to be affected due to acquisition of land. The total estimated cost such and such. Now, after discussing all this, the certain conditions were given which NHPC was expected to comply. Roman 2 will be relevant, specific conditions. Roman 2. The details of land holding of affected persons whose land is being acquired shall be submitted to this ministry, including regional office. The RNR benefit, the doctor will take note, RNR rehabilitation and resettlement benefits for the land losing householders will be as per the right to fair compensation and transparency of Land Acquisition Act 2013. Additional provisions shall be given as per the state RNR policy 2008. Below the entire thing is when for those people who are facing displacement. This was the benefit to be given to them. The condition talks about. The condition doesn't talk about the beast of the people, because here the displaced people are being settled. The land is required for the settlement of those people who are displaced from the main project. Now, we clarified this in our rejoinder, which we filed today this morning. Now, in our rejoinder, few relevant paragraphs I will just place before the lordship, explaining the situation. para 5. At page 94. Now, before that, my lord, annexure A and annexure B are annexed here with my counter affidavit. This is, my lord, the proposal, forwarding the proposal, because it is the main project I am talking about. Lordship will find annexure A. Annexure A, 18th August 2011. Proposal for diversion of 5056.50 hectare of forest land for construction of Dibang multipurpose project on Dibang River and Lower Dibang Valley, such and such. It's a proposal that has gone from the government of Arunachal Pradesh for in principle approval of the government of India under section 2 of the Forest Conservation Act. Because it was a forest land. Paragraph 2. The status of proposed project area is USF, community land, such and such. Details are given below. The proposal by this page of Arunachal Pradesh. Then below the next page, annexure B at page 100. Then principal approval. This is the in-principle approval, all conditions given by the government of India. The idea is to show below, look, that project was different. It was USF community forest land. Therefore, in compliance of section 2 of the Forest Conservation Act 1980, the state forwarded the proposal for in-principle approval of the government of India under section 2. Consequently, government of India gave the in-principle approval. Here, that is not the case. All these years have passed by since the war. Nothing has been done because it is not a forest land. It is not a USF land. Now, para 5 of my affidavit. Para 5, I need to know, at page 94. That once project, I am talking about the main project. Once project get completed in the reservoir is filled in the Dibang Valley district, a total of 340 PM displaced. Out of the 340 project affected families, 107 project affected families opted for resettlement, and 233 project affected families opted for monetary compensation. Land measuring 142.61, the present case, hectare was acquired at Bishpak Nagar, Lower Dibang Valley for resettlement of 41 out of 107 project affected families, because they are doing the consent. For the remaining 66 PF, land has not been acquired as yet. Therefore, the resettlement of 142.61 hectare of land was acquired at Bishpak Nagar in Lower Dibang Valley under section 10 of such and such Government Regulation 1947, against which an award of rupees such and such dated 23/1/2019 was approved by the government of Arunachal Pradesh. The aforementioned award such and such. That it is stated that the 142.61 hectares of land acquired under Regulation 10 at Bishpak Nagar is neither the part, this is important, my lord, is neither the part of the originally proposed 5056.5 hectare land, nor of the 4577.84 hectare of USF land, for the diversion of which there is in-principle approval of the government of India under section 2 of the Forest Conservation Act. It is not the part of that. That the acquisition of 142.61 hectare of land at Bishpak Nagar is for settlement of those 41 displaced families who are likely to be displaced from 4577.84 hectare of USF land on the construction of Dibang multipurpose project. The environmental clearance letter, the particular letter I am referring to, not which they had annexed, is still annexed in its own affidavit. The particular letter, environmental clearance letter dated 19/5/2015 was issued in connection with the rehabilitation and resettlement benefits to the families which are losing households over the diverted 4577.84 hectare of land, and should not be confused and or linked with the acquisition of 142.61 hectare of land at Bishpak Nagar, over which 41 of such displaced families will be set. So this I have clarified. And the two annextions. Now, lastly, I will refer to the two legal provisions. Should I leave it for tomorrow, at least for half an hour, or only 15 minutes?
Okay.
All right. Let I want to give something, something in reserve for them, so that they don't protect themselves. At least something of my sleep.
My lord, I will, with your lordship's permission, yes, I will need a little bit of liberty, man. I have a part-heard matter fixed before my lord, this is Ruthanguma in Guwahati. That is a pretty long matter which is going on. For that, I am required to be, I am on legs and I am in the midst of my arguments. I have to go back today. My arguments may be kept for Thursday. I'll come back on Wednesday.
Thursday.
Thursday.
Pardon?
Here.
Sir, I won't be here during your arguments. Don't.
I think on BC in that 20 I said.
Oh, okay.
BC,
I can, once my learned friend AG finish the argument, then I will make my argument because I am the beneficiary of that particular award which is given to the Now your lordship has hearing his case 242. If anyhow your lordship allows this case, then my lord then 30 goes. And if your lordship doesn't allow, then 232 automatically will stand. So I am the beneficiary of that, the award which was given in my case. So I think the AG has to reply to this cabinet decision. I will also.
Cabinet decision, I think you are not even questioning.
Can see what I said. I will not challenge because that doesn't go against my interest. The line of argument I was saying, I am not required to challenge the cabinet decision of the government of India. I place it to what the cabinet decision is and why I am not challenging. I will explain.
Perhaps, my lord, since my learned friend Mr. Das has also filed a writ petition seeking implementation of the award. Perhaps he may like to argue first, because that will cover most of the arguments advanced by Mr. Tiwari. And that way I can iron out the creases. Whatever, I will be before your lordship on Thursday.
There is absolutely no problem. Because he challenging my learned friend Tiwari challenging the award which is compensated, which has been estimated by the state, which is the net present value has been estimated in my favor. Now he is saying that what I have understood from his argument, that you cannot apply that particular R&R policy of 2008. It is only what, if you are entitled and benefit to be given is under only the Lara Act 2012. That's what I have understood.
That's sequence.
That's what I
Number is technical part.
So now the question is that I am the beneficiary because the government has given this award because I am entitled to get the benefit in our policy of 2000. So that has to be, I think, my humble request is that I will argue my part because my part was very limited so far as being the beneficiary of the award.
I can, there is not a problem.
That's what I felt. Because 230, if you are not to my petition, is what my lord I have annexed the notification. I have annexed the correspondence which my learned friend has addressed to your lordship in 242. Certain documents which how the NHPC was agreed when the final award was passed. Then they issued a letter that no, how can you pass this final award by calculating this by 25% net present value? We are agreed by that. You cannot calculate that. So all these are annexed to my petition also. So it's only a legal issue which the lordship has to decide. The net present whether I am entitled to get the benefit in addition to the Lara Act of 2013. So I'll address my there is no problem. Once my learned friend closes the argument on Thursday, I think Thursday.
I should not take more than 1 hour.
I also not take much of time.
1 hour maximum.
And my
Okay,
learned friend,
on that day,
I think
we will list
my
as
learned friend.
top of the list matter.
Yes. My learned friend can finish it off.
One thing is there, because it seems absolutely certain that next week also I may be required to present, maybe from Monday or maybe on Tuesday. I will try to be here. Thursday may be difficult, either on BC. If something goes wrong or not, 100% Monday I will be here next week.
Next Monday.
Next Monday.
So we can complete, my learned friend can complete tomorrow. He's saying he's take 15 minutes.
But reply.
Reply. We will complete our part on Thursday. If any reply is to be given, he can give on Monday.
Monday.
My lord, best part that let him conclude tomorrow. Then we will, my learned friend AG will give a reply on Thursday. Then I can do my part also Thursday. Whatever reply is there, then thereafter my learned friend give a reply.
And firstly, it follows that both my esteemed colleagues are getting sufficient with these. So anyways, I'm also trying to find something within space after their arguments. After.
So now you want to continue or?
I'll take it tomorrow at least.
Okay,
Because I'm here tomorrow also. I have
okay, okay.
not one only one player, you know. Immediately after this case, there is one service matter. Item number 20 and 21. It's a small matter, won't take a long time at all. Contrary to what my member friend has accused me of. It is indeed small. Item is ready in writing. I will finish it up to not in less than hour. So
Tomorrow?
Tomorrow.
Okay.
So at least that may come tomorrow, because if I don't mention it,
What is the number?
last two, item 20 and 21.
20 and 21.
Yes, sir.
Okay, all right.
My entire write-up is there.
This is the matter tomorrow. Okay. Tomorrow.
I will conclude not by part. 15-20 minutes I will.
Okay, okay. Both the parties are represented by their engaged counsel. Part in part, list the matter tomorrow. So do we list it as first item?
Yes, but not.
Okay.
This will
Top of
partner matter.
Partner.
No, part.
Partner.
Yes, indicated partner.
Maximum 15.
No, already dictated.
Yes, and only one prayer before the lordship Thursday. If it is not income, I don't know what will be your lordship list. Then it can be on top of the list.
Okay.
Yes,
Okay.
that's only one request.
Tomorrow we will pass the order.
Yes.
That order. Okay.